Hey guys, hello everybody. Sorry, a couple minutes. Sorry, running a couple minutes behind, but hello everyone. Welcome. Say, wow, we got a lot of people here. It looks like so far, at least. Well, going back to like 9 o'clock this morning. So let's see what everybody's up to. Yeah, about damn time. So, hello everybody. If you are new, it says, "Ben, I pity your toilet." Makes. My name is Sean, also known as Potentially Criminal. I am an attorney over in the Cleveland, Ohio area, focused on criminal defense. But today we're not doing anything criminal related. We are focusing on what's going on with former President Trump and his hearing and oral arguments with the Colorado Supreme Court. If you guys remember, a couple weeks ago, his candidacy on the Colorado ballot was challenged by Citizens for Responsible Ethics in Washington, a watchdog group who claims that he engaged in insurrection and is ineligible to serve under Section 3 of the 14th Amendment. So we'll go through the judge's ruling in a second. The judge did find that Trump had engaged in insurrection after the multi-day trial, but determined that Section 3 of the 14th Amendment did not apply to him, so therefore he was still allowed to be on the ballot. Now, what did that turn into? Well, for him, for Trump, obviously that means he could be on the ballot. The way then it works is the group who sought to remove him did not like that outcome, so they appealed it to the Colorado Supreme Court. So then Trump appealed it to the Colorado Supreme Court because now they get to say, well, look, we didn't engage in insurrection, so overturn that part. And obviously the other side saying, no, overturn the second part that the 14th Amendment does apply to him. So we will see how that goes. And that's going to be the breakdown today. They have a 2-hour time limit total. It's going to be 1 hour per side. So I don't know. I assume it's Colorado going first, but I don't know. I don't know who's going first. It's going to be a little iffy there. And hold on here. I was trying to bring up the Colorado. So I got to bring up the website here for them because they do have their own. Well, it's not popping up right now. Hold on. They each get 1 hour. And I'm assuming Citizens for Responsible Ethics in Government goes first. It's certainly up to them. I mean, how they want you to do it. Typically, though, the party seeking appeal goes first because they're the ones demanding it. But, is what it is in that regard. Let's see if we can bring this bad boy up. There we go. Oh, it's actually saying at 2:30 p.m. That's interesting. But we'll use that. I wonder if they get super chats and there's people. The Colorado Supreme Court's gonna have a bunch of people go run around screaming, building N-word towers on their feed. So that would be hilarious. People spamming it and advertising. So Richard O says, let's say he gets locked up and still gets voted as president. I'm curious how that would work. I don't know. But we do have Eugene Debs, who ran on the Socialist platform in 1920, ran for the 1920 election and got 1 million votes, which doesn't sound like a lot, but for 1919 and the 1920, it was a big portion of America. That's really the only example we have. But this case has nothing to do with whether or not Donald Trump gets locked up. It's all about whether former President Trump's allowed to run on the ballot. Now, there are issues. Can he be written in? Typically, that's going to come down to state law that you can write somebody in. They still have to qualify. They could say he's not qualified to run in that regard. It'd be no different than if you wrote in a 15-year-old. Well, the 15-year-old can't run for the ballot. Even if they get 100 million votes, he's not eligible to serve. So I think that's the argument that would be made there. Buster over on Twitch. Hello, Buster. Pitchlock says latent boomer by proxy. Yeah. Nico says, man, that Colorado court seal is kind of dirty. Yeah, but it's the court. They're not really spending money on it. So that's just how they roll. Now, before we get too far, I want to grab, I had it, but I lost it just now. I'm trying to find it because I did have it and I just lost it. And I'm trying to figure out where it went. Where did it go? Because I lost the damn thing. I canceled out the wrong tab, which is not what I wanted to do. Now, some of you are wondering, why is it going straight to the Colorado Supreme Court? I know somebody asked me this earlier. They sent me an email about it. There are multiple times where when you come to these types of issues, especially with election problems, there are certain matters that go, you have a trial court level hearing, and then if it's not accepted, you immediately go to the state Supreme Court. It's not a common thing that happens. Typically, you'd work your way through the process. But the way this works, number one, if they waited too long, we're going to be in the primary season very quickly. And Colorado's primary is Colorado's 2024 primary is March 5th for the Republicans. So that would be cutting it really close. I don't even think it's by law you can go to the appellate court. I think this is the next stop, which I think makes sense. Get it done and get it over with. So that is where we currently are. Sorry, guys. About to sneeze my head off there. Find all my yes. You can find that, and I need to not do the boomer thing and actually pin the link. I know some of you guys are also wondering, oh, no Rumble today. Guys, I don't always do Rumble for these types of things. That's a ton of crap to set up and kind of just, don't have all the free time to get that stuff done on a daily basis. So my apologies. Also, you guys will live, I promise. I totally promise on that regard. So it looks like we're not starting till 2:30. It said, I'm sorry, 1 time. It looked like from what I understood before, they were starting at 1 o'clock, but oh well. We will start. We'll start when they start. Oh, if the court doesn't want to start till a certain time, there's not a whole lot we can do about that. So there's not much you can do about that. So we're going to be starting then. Ghost of Speedy for 199. Thank you. Is saying thoughts on Nick's wet brain. I don't know. I don't know what it is. I don't know what's going on. But yeah, something's changed. I just don't know what. I'm not a doctor. Not a doctor. Don't pretend to be one. Well, I do pretend to be one because I have a Juris Doctor, but I'm not that kind of doctor. So, but something's up. I just don't know what it is. So, but yes, thank you for the super chat. Nice avatar as well. Adam says, "Aren't all brains wet?" It's Google it. It's a specific thing. Rich said election questions might be in the original jurisdiction of the Supreme Court. Very true. That could also be how it's set there. Yorick is saying, could I not say party petition the court for a different start time so they could watch on the lunch break? Be a little late, but you could try if you get the filing over there. Yeah, I know. I'm leaving 23 cents of Rumble on the table. But since we do have the time, I do think it is important to look at what's going on and what the court determined, because that is that is the, well, I mean, really, that's where we go from here to see what happens. Hold on. So what we're going to do, and this is the ruling that we have, and this is the actual ruling that came out of Denver. This is the actual thing from when Joe was watching the trial and Judge Wallace, who's the judge in this case, admonished him to not watch things on the internet. This is the actual case. So what we have is the date when this was filed. And this is just, it's weird, but it's how Colorado does things. So it's November 17th. And it's these people here, they make up the group sponsored by Crew, the Citizens for Responsible Ethics in Washington. And this is against Jenna Griswold in her official capacity as Secretary of State. Now, this was the initial way the case was filed because you have to sue the Secretary of State to remove Trump off the ballot. You're not necessarily suing Trump specifically, but for the interveners, because it matters to them, they're allowed to be involved in this case because it's their ballot. You know, they're the ones on the ballot. It's obviously Donald Trump and then the Colorado Republican State Central Committee. So that's why they showed up. But the initial case is, Anderson et al. V. Griswold. So they bring up that the case went to trial, and the petitioners through there, and they talk. This is just the beginning, the preamble, yada 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 yada. The court makes the following findings and facts and conclusions of law, which means its determinations. Oh, yeah, I had a cold for, well, and my nose is always running. I have allergies really bad, so it's going to happen no matter what. I apologize if I'm potentially sniffing, trying not to. So the petitioners are the people who brought the suit, and they bring two claims. First they make a claim pursuant to the Colorado Revised Statutes, and the second they requested declaratory relief against both the Secretary and Trump. The declaratory relief was that he couldn't be on the ballot because he's not constitutionally eligible. And that's the big one. So Trump tried to get this removed to federal court. The federal court remanded the case, finding the secretary was not a nominal party. And what that means is that the party isn't really that relevant. You can't just name a state party to hide a federal action. Because sometimes people might try to do that, and it does happen once in a while. But in this case, they were trying to, obviously, they wanted to remove Trump from the ballot, but they had to. The Secretary of State is critical to this case because they're in charge of the ballot. And Trump tried to have it removed, and the federal court said, well, no, this is actually a state issue. You guys have to deal with it at the state level. Obviously, he thought he had better chances at the federal court level, and I think that could have been different, certainly. So the state Republican committee filed a motion to intervene. Trump filed a motion to dismiss under as an anti-SLAPP motion, a strategic lawsuit against public participation. In that motion, he claimed that all these stem from protected speech or the refusal to speak, and because the speech connected to concerned election fraud and a hard-fought election, they are the epitome of public issues, which is a fair argument. He also argued they are unable to establish reasonable likelihood of success. As a result, Trump argued the court must dismiss the claims. He also filed a motion to dismiss. And, these are fair arguments that they might not litigate constitutional claims, that it wasn't ripe, which, hey, these are the arguments they tried to screw over. Oh, it's not ripe. Now it's moot. Now there's latches. Nothing wrong with trying to make that argument. That the state law does not provide grounds used the 14th Amendment to bar candidates. And fourth, there was no standing for the declaratory judgment because there's no particularized injury. I think that's actually an interesting argument to make. What injury did these people suffer? What did you really suffer? Oh my God, he's a Nazi. That's not really it's not really how that works. The petitioners, as they responded, agreed to dismiss the declaratory judgment claim, seeking the injunction. That has since been dismissed. That was dismissed before the trial started. The Republican Party filed a motion to dismiss, arguing under Colorado Rules 12b-5. So we're familiar with 12b-6, failure to state a claim on which relief can't be granted. This 12b-5, actually, what is Colorado 12b-5? Because I think I know what it is, but I want to make sure. Colorado Civil Rule 12. Colorado Civil Rule 12A, not A. 12B. Oh, so 12b-5 is their failure to state a claim upon which relief can be granted. Okay. So and that's why I looked, because every state's different. In Ohio, that's 12b-6. Federally, that's 12b-6. Colorado, 12b-5. So that's why you have to look. That is why you have to look. Where did we go from here? Sorry, missed my spot. So that it infringes on the First Amendment rights, that the enforcement of this, it's not ripe. They also offered additional arguments, and they all went to trial. So we need to get to, there's multiple responses here, but those are the basic things. I want to get to the actual findings from the court. Okay. So this is the actual big one here. The court made its ruling in everybody's motions. The claim under Colorado Revised Statute 1-13 and 1214, which are 113. 113 is neglect of duty and wrongful acts. Okay. And that's what they talk about. That's their allegation. And then 1-4201. And this is the actual statute that covers putting the names on ballots. And this is the one where they're attacking and they're asking the Secretary of State not to put Trump on the ballot. They found that the issues were ripe. So the issues were ripe and they brought it properly. That the issue of whether or not the state law applies under the 14th Amendment is preserved for trial, which that means they're going to trial. Getting further, the First Amendment grounds, it's not violated if the state qualifies the candidate on the grounds of his eligibility, which, yes, if he's not allowed to run, well, then they can do that. So, the Secretary of State has the legal authority to vet candidates, which also makes sense because, it's the requirements. Are you 35 years of age? Yes. Are you a natural born citizen? Yes. So, and this is the question about whether or not the 14th Amendment applies. So, the Secretary of State has the right. Now, they found a couple other motions premature. And then finally, they point out that the only way the court can afford any order is to comply with the election code, and that there had to be a hearing, and the declaratory judgment was improper. So the court can't just look at all the motions and make a ruling. It had to have the hearing. So we're going to get to the actual hearing part. Wait. So they had a 5-day trial. This is the one Joe covered, and it concluded on November 3rd. On November 15th, they presented the closing arguments. So at this hearing, they brought up the January 6th report. There was objections to the omission of it, and the court made a final decision on the admissibility of it. There were issues of hearsay. There were a lot of issues regarding the report, period. And they cite a bunch of federal law to get to the part about whether or not they bring up, though, the party challenging the admissibility bears the burden of demonstrating that the report is not trustworthy. Okay, well, we get through that, and they talk about the trustworthy factors. So they point out that just because it's not entitled to an additional presumption of trustworthiness or reliability beyond the one already established. Simply by virtue of being from Congress, that's not enough. You have to look at, well, were there other parties involved, which is kind of important because, yeah, even the courts recognize you can't trust Congress. You never could trust Congress. Can't ever trust those guys. Let's see where you guys there. Turnip says, speaking about former President Trump, they can't even give him the basic courtesy to everyone else in this. It simplifies things putting Trump in there. I don't think actually it'd probably be any different of an issue if it was any other person or candidate. So I'm not particularly thinking that's different. But I understand where you're coming from. Now, when people are speaking, yes, they are trying to be disrespectful and assholes to him, but people do it on the other way. So that's not really a difference of a issue there. But very good question, Turnips. Thank you. Parallax says, so when does the train content start? My God. Which train content? That's the real question. Please specify. Request unclear. And just so we can double check here, we'll fire up the court real quick just to. We are still standing by. Still standing by. As a NSYNC would say, bye, bye, bye. So, just waiting, and I want to make sure you guys knew that. We are going to continue reading along here, just so you can see where we are with this. The court determines that the first three factors weigh strongly in favor of reliability. The investigation started 6 months after the events of January 6th and ended less than 2 years after the events took place. As a result, the passage of time no way affects the reliability. The investigation was conducted by a well-staffed, okay, yeah, there was a lot of people involved, a highly skilled group of lawyers. Okay. And led by a former U.S. attorney. Okay. Hearing was conducted over 10 days and 70 witnesses testified, all of whom testified under oath. Yeah, because none of them would ever lie. Then they destroyed things like transcripts and deposition information. Thankfully, defense counsel has a lot of those. But yes, the head of the committee destroyed a lot of the depositions because, I didn't think people need those. They had large volumes of records that independently evaluated. None of the findings were contradicted by the evidence presented at the hearing. Yeah, but I'm not sure you'd be allowed to present that because now you're having a trial on the hearings. So even if you tried to bring that up, yes, they bring up the possible motivation problems. Yes, and I'm sure Liz Cheney has no motivation to go after former President Trump. I mean, it's funny, all the people who like Liz Cheney, considering she was one of the architects of the Iraq War. Yes, she was. It wasn't just her dad. She helped her dad. She was a hack in the State Department. So it was very funny to see people cheering on Liz Cheney, and it's like 20 years ago, you guys wanted to drag her through the streets, but time heals all wounds, I guess. Isn't that how it goes in life? Isn't that how it goes? So they point out that the admissibility of the report is that all 9 members of the committee were biased against Trump and deep personal animus. There was a lack of involvement by the minority party. Yeah, it was a big issue. Through the examination of Mr. Heafy, Trump presented evidence prior to the formation. Numerous members had expressed disdain for Trump, and they believed he was responsible for the events of January 6th. Yeah. Yep. And they get through all of that. They keep pointing out that the court finds that, the testimony was, credible and holds that any perceived animus, they claim did not taint the conclusions of the January 6th report in any such way that would render it unreliable. Yeah, I'm sure that they were not going to do that. The judge also says that the political bias would make it incompatible. If the finding would make it incompatible surrounding with case law surrounding the admissibility of congressional reports. A congressman who testified and was on behalf of the state said there's always a measure of political bias or motivation, which, fair enough. And courts have admitted congressional reports for decades. So they get through all this and the court makes its decision. While the court agrees that had there been further greater Republican participation, the events pointed to by petitioners demonstrate the Republicans had a meaningful opportunity to participate, but simply chose not to do so. Did they really? Speaker Pelosi rejected 2 of the 5 recommended Republicans for the committee the minority leader put forth. She admitted the decision was unprecedented, and the fact that congressional Republicans chose not to seat the 3 Republican members she was agreeing to seat or nominate new members, the boycott of the committee is not a valid reason to reject the report in total. Now, overall, on its face, that is a fair assessment. But for her to argue that this was a fair hearing or a fair process, I don't think that, it's an issue of calling the balls and strikes. It looks good until you actually look into what she's calling balls and strikes on. So, the 2 Republicans who did not sit on the January 6th committee, the 2 that did, Liz Cheney, I love this part, former reps. Yes, the former representatives. Liz Cheney and Adam Kinzinger. So she also points out that Kinzinger, even though he worked with the Democrats, got redistricted. And then Liz Cheney just got trounced. So, well, they were both duly elected. Yeah, what happened to them afterwards? Apparently people thought they weren't good. But c'est la vie. C'est la vie. So, yeah. They point out that the findings were unanimous. There was no minority report, and this includes the 2 Republicans who sat on the committee. And all these factors cut against the intervener's argument the lack of participation of the minority party resulted in the report reaching unreliable conclusions. So, yes. There's no evidence that the committee coerced witness testimony, refused to hear testimony they did not want to hear, or disregarded credible exculpatory evidence. The only evidence presented, which I think is funny, the judge says, well, there was no evidence presented at the hearing that could arguably show disregard of certain evidence by the committee, is the fact the committee chose not to contain certain testimonies credible. But once again, I think we're playing word games there, but okay. Okay. Sending me a conductor's cap and a handkerchief. Thank you. Vodka's saying, what are the chances he wins this lawsuit here? I think we'll get to that. But I just want to read what the judge says here because we're going to get to things. Richard O says, we have a practicing lawyer here. Drop him a super chat. Yeah, certainly that wouldn't be a bad idea. You can do that down below. Nico says the Supreme Court building in Colorado is kind of ugly. I mean, it's better than other buildings. I mean, certainly it's not the Ohio Supreme Court's building, but it is what it is. I mean, you can't. We're not going to have an architectural. We're not going to do architecture review. We're not doing that today. So the thing the court then focuses on this case is a judicial proceeding, and it's an administrative proceeding. This is not a typical claim. This is being brought as an administrative challenge. Okay? And the judge acts as the fact finder. There's no jury. There was no jury present. He's not entitled to a jury. And ultimately, she gets to, because he was unable to provide credible evidence, the findings of the court has difficulty understanding the argument that it should not consider its findings which are admissible under the Colorado rules of evidence. Okay, well, so yes, the report is reliable and trustworthy and therefore admissible. The court only considers the portions of the report which are referenced in the orders and no other portions in reaching its decision. Let's see what this footnote says. So they submitted 411. There were 411 findings submitted, and she determined that only 143 of those findings were inadmissible. And their proposed findings of fact and conclusions of law, which is something in the civil trial, a proposed finding of fact and a conclusion of law is what you do when you're trying to show the judge, here's what we want you to argue, here's what we're looking at. That they submitted 98 findings. So after everything's done, you're trying to say to the judge, here's what we want you to accept, here's how we want you to rule. And then the court says it's considered only 31 of those findings in this order, which I think gives some credence that the court, for the arguments that the Court went through and parsed this down pretty far. Now, I mean, that's also a big, for somebody to sit there and say, well, it sounds like they submitted a bunch of bullshit, which from watching the trial they did, but I do think it's interesting. If you guys remember, Congressman Eric Swalwell testified at the hearing. And his experience with 2 prior electoral college certifications prior to 2020. His role in the Trump impeachment after. Yes. The court gave weight to Congressman Swalwell's testimony in finding that there was an insurrection. Okay. One of the officers for the Capitol Police testified. He was assigned to the Civil Disturbance Unit. But it was an insurrection. Why were they there? The group was told to put on their riot gear because the outside lines had collapsed and breached. Officer Pingan described hand-to-hand combat for up to 3 hours. Well, they fended off the attackers. Okay. Actually, hold on, guys. Sorry, I need to take this real quick. Okay, that was not ordering takeout. That was doing some real lawyer stuff. Thank you, everybody. Har, 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 char, 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 char. Funny guys out there. It's like Arnold says in Commando. You're a funny guy, Sully. That's why I'll kill you last. All right. So he's one of the Capitol officers who testified, and that they're finding there was an insurrection and that the mob was there on Trump's behalf. Okay. So a professor of sociology testified. Yes, professor of sociology. That is such a noble thing. Qualified as an expert in political extremism. Oh yes, I'm sure. Those Pepe memes are so dangerous. Including how extremists communicate. Okay. He's been studying political extremism and violence for 27 years. I'm sure he has. In 3 ways: field work, spending time embedded with extremists in their natural environments. Sounds like Jane Goodall. Formal interviews and archival information. He spent thousands of hours doing field work with three primary perpetrators: the Oath Keepers, the Proud Boys, who did nothing wrong, and the Tree Percenters. He further testified he's interviewed 217 right-wing extremists, and that 14 of those interviews were with the Proud Boys, Oath Keepers, and Three Percenters. So who are the other people? He interviewed 14 people that were there. That's it. You know, when they claim that Trump's words before and after January 6th might be seem innocuous to the average listener, well, what is the go there in peace part? Be seen differently by an extremist. So they say Trump intended and incited the violence on January 6th. Okay. Professor William Banks testified. He was a law professor at Syracuse. He taught classes in constitutional law. He founded the Institute for National Security and Counterterrorism. What did he do here? He was qualified as an expert on president's powers to stop domestic attacks on the government, and that then President Trump had to call in to stop the attack on January 6th. Okay. That then President Trump had to hand over the DC National Guard. It's the only authority he had in the National Guard in the adjoining states. What did they want him to do? Like kill everyone? Like what was the finding here? That Trump had the authority to call in reinforcements. Well, I thought calling in the National Guard was like a dictator move, and using the army to suppress people wasn't right. I thought we weren't allowed to do that. I thought tear gassing people was a war crime. Just remembering what happened in the summer before. He thereby recklessly endangered lives of law enforcement, Congress, and the attackers on January 6th. So scary, so scary. Another law professor testified. Gerald Magliola, or whatever, how you pronounce his name. He's an expert in history on Section 3 of the 14th Amendment. This is bullshit. Nobody ever studied the 14th Amendment. Nobody ever studied Section 3 before this. No one ever cared about it. You've been studying the history of the 14th Amendment for several years, maybe other parts of it. And then in Section 2020, he wrote a paper on Section 3 of the 14th Amendment. Yeah, okay. Yes, I'm sure he was concerned because President Trump might be a Nazi. Oh, he might be a bad man. I'm sure he was just innocuously studying. Hey, nobody's ever looked at this. I'm sure after this, he's going to move on to the Third Amendment because you never know. But they determined he engaged in insurrection. Yes. Brand new in there. Nico says he interviewed Baked Alaska. Oh, that's brilliant. That is brilliant. I'm sure that was an awesome thing. So, Rich G says we wrote it in a paper. Yes, that's true. But he said it happened. Why would he lie? Still nothing over on the Colorado Supreme Court. I just keep updating it. So the court gave weight to his testimony, but ultimately rejected it regarding Section 3 of the 14th Amendment applying to Trump. Yes. The Colorado's deputy elections director, she testified about how the state has traditionally handled qualification issues. And this was brought up just to show that they had the right to bring this and the Secretary of State could determine it. She was extremely credible. The court gave weight to her testimony regarding the historical practice of Secretary of State when it would traditionally prevent ballot access and when it wouldn't. Timothy Heafy testified. He was the former chief investigative counsel for the January 6th committee. Yes. He was a U.S. assistant attorney. He was an assistant U.S. attorney from 91 to 2006. He did white-collar defense until Obama appointed him as U.S. attorney for the Western District of Virginia. In 2017, the city of Charlottesville hired him to investigate the deadly Unite the Right rally. Oh, no, he's an expert on this stuff. I'm sure he didn't have an axe to grind there, but what do I know? He's a qualified and seasoned investigator. I'm sure he's worried about Trump becoming a Nazi. The Trump gave weight to his testimony to admit specific findings on the report. Yes. Kash Patel testified on behalf of Trump. If you guys weren't aware of him, Kash Patel was the former chief of staff to the acting Secretary of Defense on January 6th. And before that, he had been involved in the Trump administration for quite a while. He testified that on January 3rd, Trump authorized 10 to 20,000 National Guardsmen. Okay. The court determines that he was not a credible witness. Not a surprise. Not a surprise. The testimony regarding the 10 to 20 National Guardsmen is not only illogical because Trump only had authority over 2,000 guardsmen. Okay, well, maybe he was. There's nothing saying he wasn't an idiot or anything. But completely devoid of any evidence in the record. Okay. Further, his testimony regarding the January 6th committee refusing to release his deposition, refusing to request to speak at a public hearing was refuted by Mr. Heafy, who was a far more credible witness. Yes, I'm sure he was. I'm sure a career Fed is far more credible. The court did not give it any weight other than that they interviewed him. Katrina Pearson testified she's a senior advisor on both Trump campaigns. She had intervened regarding the disputes that arose on January 6th. Trump agreed that they weren't going to include people, like they weren't going to let Alex Jones and Ali Alexander there. She also testified that Trump wanted 10,000 National Guards. Okay, the court's saying that the court has no reason to disbelieve this testimony, but mentioning 10,000 National Guardsmen is not the same as authorizing them. Okay, but he's like, I want a gajillion National Guardsmen. Mr. President, you can't do that. Okay, but that shows he wanted a lot of National Guardsmen available. Sounds like he didn't. Sounds like he wanted them there, which refutes what she tried to make the claim for above. I mean, I'm just a simple attorney from Ohio. I'm no fancy Colorado judge up in the mountains of the, Rocky Mountain High State. But I'm just looking into that, and I got a little bit of an issue. A little bit of an issue. A little bit of an issue for that tissue. She testified she spoke with the January 6th committee for 19 or 20 hours. The court finds her credible, and the court believes that Trump chose the speakers for the rally. Okay. And that he knew radical extremists were going to be in Washington. Okay. And that's why he didn't let them up there. So isn't that good? I mean, do you not did she want him to put those guys up there? Did she want her to put the frogman there? Because he didn't. So he was asking for, he is like, I want a gajillion guardsmen. And he's like, I want this, I want that. Sir, that you can't have that. Oh, well, then what do you want him to do, Judge? I'm a little curious there. And this goes on and on and on and on for about 100 pages, but we'll get the last little bit of this here. Amy Kramer testified for Trump. She's the founder of Women for America First. And, they kept the people she described as wackos from speaking at the ellipse. The reason she didn't want the wackos to speak is she was worried they might incite violence. Okay, so the wackos didn't speak. From the ellipse, she didn't witness any violence. She was unaware that someone in response to Trump's speech yelled, "Storm the Capitol." Not Trump. Take the Capitol, not Trump. And take the Capitol right now. That's not Trump. She didn't walk with the crowd to the Capitol. She didn't do any of that. The court found her testimony to be credible, but largely irrelevant, other than she was concerned about the speeches at the ellipse. But he's saying that there was nothing there. This guy here, though, he was at the Ellipse from 8 to 10:30, 2 hours before Trump spoke, didn't see any violence. Yeah, this guy doesn't really help anything. It's irrelevant. Tom Bjorklund testified. He's the party treasurer for Colorado for the Republican Party. He wasn't at stage at the rally. He marched to the Capitol and claimed he didn't see any violence. Because obviously, yeah, he couldn't see violence, but yeah, this isn't a good one. Yeah, there were a lot of people there being violent. I mean, that's not impossible. So, Ken Buck testified. He was there, but he wasn't scared. But it's because he did not have a cell phone and did not realize the extent of the attack. Um, so that is the issue there. And this goes on for quite a bit. I mean, there's 102 pages, and she goes on and on and on. So, and this is all of her findings of fact and goes through all of them. And this is the entirety of it. It's 102 pages, and we're not going to get through the entire thing there. So we'll get to the conclusion. And the conclusion is that he has to be placed on the ballot when it's certified on January 5th. So this is where we got to get this done, is the issue for the Supreme Court of Colorado. So that is where we stand currently. Why am I small like that? That was weird. So here we go. Yes, Trump's response is, "Quiet, you stupid woman." Yes, Patel did a very good job on cross-examination dealing with the lawyers, but that's yeah. It was a very, very, very good cross-examination. Richard O says, "Did AJ get pulled into all of this, or has he escaped it?" The Frogman's okay. The Frogman has gotten clear, but the Frogman's still dealing with his stuff over in Connecticut, where the Sandy Hook families are now like, "We'll take $80 million instead of $1 billion," because they know they're not going to get what they're trying to get. Ammo's currency said based. Adam K says, "Doesn't matter when the judge already decided." Yes, I agree. I think the judge has already decided things, but we got to deal with what we got. Vodka Blood says, "Wasn't like 100 billion or something like that?" No, it was like a billion, I thought, ultimately, in Connecticut. So, Brandon Garcia for 129 Mexican pesos is saying, "This feels like legal bloat." Also, by the way, thank you very much, Brandon. This feels like legal bloat. Only an actual conviction should matter, which he does not. Been convicted. The January 6th report in the end is just opinion. Yes, but the judge does cite things that allows her to make the conclusion she did. As much as you want to say it's bullshit, it's she made the ruling she did, and I think ultimately the court's going to leave a lot of this alone, because to overturn this, you have to prove that she didn't meet some standards, and her determinations. I mean, it's 102 pages. And to say she was awful on her determination about Section 3, well, then you call into question her determination on the insurrection. So it's a bit of a double-edged sword for the people challenging this. I think you just leave it alone and go, they should have left it alone. And for Trump, yeah, there's a risk there, because now you're saying, well, the Section 3 part is right, but now you're saying her insurrection finding was wrong. I think ultimately the court's going to leave it alone. What is going to happen? Guys, hold on. I need to take this. Different call. I'm not gonna lie, I love you guys and what you are guessing is going on there. So it is very, very humorous. Let's see here. Oh, I forgot. We still I think we have a half hour to go. Let's see if anything has changed yet.
Yeah, that those who took an oath to support the Constitution and then betrayed that sacred duty by engaging in insurrection against it cannot again be entrusted with public office. After finding that Trump engaged in insurrection, the district court nevertheless held that he is allowed to run for president again. That ruling was wrong for 3 reasons. First, it was wrong on the text, because the broad words office and officer clearly include the office of the presidency and the person who holds it. Second, it was wrong on the history, because the one thing that supporters and opponents of the 14th Amendment agreed on at the time was that it disqualified leading rebels like Jefferson Davis from holding any positions of substantial federal power up to and including the presidency. And third, it was contrary to Section 3's core purpose, because who could more easily subvert our democracy from within than a commander-in-chief who has already tried to do so before? This court should reverse. I'd like to start with the issue of whether the office of the presidency is a disqualified position, an office under the United States, because I think that question resolves the question of whether the president is an officer.
As a preliminary matter, good morning to you, or good afternoon, Mr. Murray. Do you think the provision is ambiguous?
We do not think the provision is ambiguous, Your Honor. The Constitution tells us over and over that the presidency is an office and that the person who holds it swears an oath of office before assuming the execution of his office. And the plain meaning of an officer is just one who holds an office. So we think the text here is very clear, that the history supports it, and certainly that the core purpose of the provision supports that reading as well. President Trump relies on what we see as strained inferences from drafting history and canons of construction on the issue of whether the presidency is an office under the United States. And you don't resort to those tools when the Constitution already tells you what the answer is. Section 3 applies to any office, and any means any, and the presidency is an office. But in addition, the history here could not be more clear.
Well, before you get to history, I'm going to stick with you on the text. It says any office ... under the United States. Can you cite me a provision in the Constitution where the presidency is defined as an office of the United States or an office under the United States? Yes, it says it holds this office repeatedly, but I think Mr. Gessler will take you on the text, and it will not, it doesn't say, I'm not sure it says ever, the president is an officer under or of the United States.
Well, a few responses to that. First, I think it would be strange to say the presidency's office, the office of the presidency, is anything else. The Constitution uses under the United States to compare federal offices to those under any state. And second, the Constitution uses the phrase office under the United States a bunch of times in contexts that I think pretty clearly include the president. So for example, Article 1, Section 6 says no person holding any office under the United States can simultaneously be a member of Congress. And basic separation of powers principles tell us that the president can't be a sitting member of Congress too and vote for the very bills that the president is going to decide how to implement and whether or not to veto.
What about the use of officer of the United States in Article 2 and Article 6 in a way that seems to be distinguished from the president?
I disagree that those are distinguished from the president. Let's take Article 6 first. Article 6 just says that all executive and judicial officers and legislative officers have to take an oath to support the Constitution. And the president does just that. Now, Article 6 doesn't tell us what exact words that oath has to use. Now, Article 2 tells us for the president and the president alone that his oath is the strictest one anywhere in the Constitution. He has to preserve, protect, and defend the Constitution. But that is an oath to support. the
So,
Constitution.
so why doesn't Article 6 refer to the president specifically then?
Because it doesn't
Why-
need, oh, I'm sorry, go ahead.
Please, go ahead.
Because it doesn't need to, because Article 6 refers to any officer of the United States, and the president holds an office, and so he is an officer. And I would add that on Article 2's usage of the phrase officer, in particular, for example, the commissions clause, which just says that the president shall commission all the officers of the United States, that's just describing the powers of the president. That's making clear that it is the president and nobody else who commissions the officers. But it would be a bit of a strange way to imply the president is not an officer, to do so in a provision that's talking about just who is the one who does the commissioning.
Well, but if we put together, thinking about Justice Marcus's question and the commission question, nowhere in any of the references to officer does the Constitution list the president. And it does say that the president commissions all officers. So thinking about those two facts together, does that suggest that the president is not an officer because he's never listed as one, and he commissions all of them? And I say he only because of historical reality.
Understood. I think one could try to create some ambiguity if you look at those provisions alone, but I think stepping back and just looking at the fact that the Constitution tells us that the president holds an office makes very clear that the president is an officer and that the general term was intended to cover the president. And I would say that not only do dictionaries at the time of the original Constitution define an officer as simply one who holds an office, but that was also very clear by the time the 14th Amendment was ratified 80 years later. And I would direct the court's attention not only to the definitions that we cited in our brief, but also to a source that Trump cites in his reply brief at footnote 54. He cites the John Beauvoir's Law Dictionary from 1856, and he cites that for a definition of insurrection, which doesn't support what he's trying to say. But John Beauvoir also defines officer as simply, quote, he who is lawfully invested with an office. That's the first definition in that dictionary of officer. And then the first example that dictionary definition gives is executive officers like the President of the United States. So if you're asking the question, what did the people 80 years later, when they ratified the 14th Amendment, think they were including by using office and officer? They would have understood that those things were synonymous. And the presidents at the time were telling the public in presidential proclamations, and members of Congress were telling them in speeches, that the president was the chief executive officer of the United States. So I think it's hard to say that the public that was considering whether to ratify the 14th Amendment would have been going back and trying to see whether there was any ambiguity in the commissions clause or the impeachment clause. They would have been relying on popular understanding, and that understanding was very clear at the time.
Doesn't it seem odd to list specifically senator or representative in Congress and not specify president or vice president in Section 3? I think this is one of the observations the district court made.
That was one of the points the district court made, and we would disagree with that because I think Section 3 pretty clearly indicates a kitchen sink approach. They were trying to cover all positions of federal power. The president holds an office. The Constitution tells us that. Senators and representatives don't hold offices. The Constitution, at least as it was originally understood, the Constitution never once says senators hold offices. It says they hold seats in Congress. And in fact, Article 1, Section 6 says no person shall hold any office and serve as a member of Congress. So it would be contradictory, I think, to say members of Congress hold an office. And if you think about the definition of office, one who exercises some kind of continuing position of authority, at least arguably members of Congress don't do that on their own. They vote as part of a collective body. And that's very different from the role of the president as the chief executive officer.
So picking up on that theme, the district court seemed to conceive of this listing as a descending order. I'm understanding your argument to be, no, this is about the three branches of government. Is it your position that that listing that appears in Section 3 roughly correlates with the same list in Article 6?
Well, I think maybe I would put it slightly differently, which is that it correlates with the structure of the original Constitution. It goes in that same order. So Article 1, senators and representatives. Article 2, presidential electors. Article 2 and 3, executive and judicial officers of the United States. And then, or officers under any state would be really Article 4. So I don't think there's anything unusual about saying that Section 3 tracks the structure of the original Constitution and not the order of importance. And I would add on that point that Trump doesn't argue that, for example, Section 3 doesn't apply to Supreme Court justices. They clearly hold an office under Article 3 of the Constitution, but they come after presidential electors. And I think it's pretty clear that they would be considered a more consequential office than a presidential elector.
And the reason the reason I keep bringing up Article 6 is because there's that reference in Article 6 to support the Constitution, an oath to support the Constitution. So I take it it's your position that the presidency is covered under Article 6, and that oath to support the Constitution is simply everyone is required to take an oath to support the Constitution. The presidency has a very particular oath dedicated, protect, defend the president. Sorry, protect and defend the Constitution.
That's exactly right. And one point I would make on that is that Article 6 doesn't provide any specific wording for the oath. And different states over time have had different language for that oath. Sometimes it uses the word support, sometimes it doesn't. Similarly with federal positions, the language of the oath has changed over time. I think there was an understanding that support the Constitution was a concept, it wasn't magic words. And in fact, in the specific context of Section 3, we have historical authority supporting that notion. Exhibit T to our opening brief we cited was a grand jury charge from 1870, where a court was asking the question, you had a state officer who took an oath, but it didn't use the words support the Constitution of the United States. And the court instructed that for purposes of Section 3, that doesn't matter, because supporting the Constitution is a concept. It's not sort of a linguistic nicety, and that any obligation to support the Constitution counted.
Speaking of, go ahead.
So speaking of linguistics, is there anything you'd like us to be thinking about in terms of intra-sentence uniformity versus non-uniformity?
It's a great question. I think Trump wants to argue that because officer and office are different words, they must mean something different. But if you look at Section 3, there's actually a real symmetry there. And the difference comes in different words that are used when you're talking about positions versus individuals. So Section 3 says, no person shall hold the position as a senator or representative in Congress, and people are disqualified if they're insurrectionists who were members of Congress. Now, those two things, I think, clearly mean the same thing, different words for positions and individuals, and so too, any office under the United States and an officer of the United States. And that's exactly what Attorney General Stanberry said in interpreting Section 3, was what is an officer of the United States? Well, we're using that in its most general sense, anyone who holds a federal office.
Well, let me ask you, I guess, two questions, one on that and one on his history. What do we do with the Free Enterprise Fund case where the Chief Justice said people don't vote for officers of the United States?
Well, this is one place where I might agree with Donald Trump, not what he says in this court now, but with what he said in a court in New York, where he said cases like Free Enterprise Fund, they're interpreting the Appointments Clause. And the Appointments Clause says the president appoints all other officers of the United States. And clearly, when you're talking about appointing other officers, you're not talking about the president. And that's usually how the question of officer of the United States comes up in these cases is, are we talking about a mere employee or are we talking about an appointed officer?
All right, I understand. So let me ask you now the historical question. You referred to the history a few times. Obviously, the first draft of Section 3 included the president and the vice president, and that got removed. And my understanding is your position is, yeah, they removed that and broadened the other officers at the end of that. I'm curious if there's any legislative history, quote unquote, to support that.
It's a great question. First of all, that wasn't the first draft of Section 3. Section 3 didn't proceed as like one draft where language was changed over time. There were all sorts of drafts with very different scopes that changed over time. And there's not a clear indication oftentimes of why a particular draft became the predominant draft. But I would also say in the context of that particular proposed amendment to Section 3 by Representative McKee, the original language covered appointed officers of the United States, and it specifically covered the president. Later, Representative McKee offered a different draft, and that draft just said any office of trust or profit under the United States. So it didn't mention the president, it just referred to any office. And Representative McKee, in defending that proposal, he never said, I'm excluding the president. To the contrary, what he said was that this proposal will exclude traitors from all positions of power in the nation, and it will prevent people from voting for any, quote, but those who are loyal. And that is at Congressional Globe, 39th Congress, first session at 2504 to 2505. And more, I'm sorry,
please,
Justice
go ahead.
Head. I was just going to add that more broadly, one thing the history does make very clear is that by the time we got to the final version of Section 3, everybody, including opponents of the 14th Amendment, knew that people like Jefferson Davis couldn't be president anymore.
So I was expecting you to follow up with the Johnson-Morrill exchange, right? You give that a lot of play in the briefs. I won't take up time to explain what it is. You understand what I'm referencing. During the congressional debate, there was an exchange that you attribute some significance to, and some scholarly literature from Professor Lash questions that obviously opposing counsel has. Can you respond to their criticism of your emphasis on that one exchange?
Certainly, two things about that exchange,
Very good
Your Honor. The
question.
first is that Reverend E. Johnson
Very, very good.
took a quick look at the provision and said, why did you exclude the presidency? And I think the thrust of his question was, it would be absurd to exclude the presidency. And I think that's what everybody at the time was thinking, was of course we're going to cover the highest office. And the response by Senator Morrill was, well, it does include the presidency. Look at the phrase, any office under the United States. And then Reverend E. Johnson agreed. And nobody came back later in the debate and said, well, actually, that language is somehow ambiguous.
And so one of the responses has been that acquiescence may have just been out of collegiality. And, you know, why are we reading so much into one exchange that might have been nothing more than a nicety?
Well, I mean, certainly that's Trump's argument, but I think that if there were some intent to exclude the presidency from Section 3, given how important that would be, I mean, think about that. You'd be saying that a rebel who took up arms against the government couldn't be a county sheriff, but could be the president. That would be a really big thing. And you'd think we would see some indication in the history of somebody coming back and saying, no, we're carving this out because it's somehow different. And there's just no indication of that at all.
Right. I guess I just struggle with how much significance we should attribute to the McKee draft or the Johnson-Morrill exchange. These things seem to be sort of conveniently plucked. I'm not sure how instructive they ultimately are in the grand scheme of things.
I think there's always a question of how instructive legislative history is. And I think here, where the text is so clear and where the consequences of saying that the presidency is not an office under the United States would be so bizarre, because you'd be saying that, for example, in Article 6, Congress can impose a religious test for no office except the presidency. And I guess you could require the president to be a Jehovah's Witness. Or that no office under the United States, the holder of them can accept bribes from foreign kings or princes under the Emoluments Clause, but that because the presidency is not an office under the United States, the president can go to a foreign prince and ask them for a title of nobility. And that those results are just so counterintuitive to our constitutional structure that a careful parsing of legislative history here, I think, is interesting, but really not terribly necessary.
But if it was so important that the president be included, I come back to the question, why not spell it out? Why not include president and vice president the way you spell out, they spelled out senator or representative?
Well, I guess I go back to the kitchen sink approach, right? They used a really broad phrase, any office under, and then they wanted to include the handful of things that may not fall in that catch-all. I think everybody knew that the presidency was an office under. And along those lines, I just direct the court's attention to about a dozen sources from speeches and newspapers that we've cited in our brief. Both supporters and opponents of Section 3 had no difficulty understanding this, including opponents. So Exhibit AD of our brief, we cite an example of a rather racist opponent of the 14th Amendment who was saying it was kind of deeply unfair in his mind that Black Americans like Frederick Douglass could be president, but no person under a disability of Section 3 could. It wasn't just radical Republicans saying this. Everybody at the time knew Jefferson Davis couldn't be president and that any office included the presidency.
So to oversimplify, or perhaps oversimplify, your reading of Section 3 really is members of Congress who are not officers, electors who are not officers, and then all officers.
That's exactly right. That is our reading, Justice Gabriel. And I see that my 20 minutes has expired. Thank you.
All right.
Just me for $9.99. Thank you. No need to comment.
Mr. Olson, when you're ready.
Well, thank you. And Richard, I saw your super chat. I will get to that one when we get a second here. So let me.
Thank you very much, Mr. Chief Justice, and may it please the court. Trump levies two types of complaints against the finding below, but neither should disturb the district court's holding that Trump engaged in insurrection against the Constitution. First, he complains that the district court's finding that he engaged in insurrection was unsupported by the facts. But he ignores the worst facts that make clear the district court was correct to find that Trump gathered, summoned, and incited a violent mob that stopped the constitutional transfer of power on January 6th.
Mr. Olson, I'm going to stop you there because I think, was the district court in a position to make those findings? That is, did the district court have jurisdiction? Is a pretty fundamental question here.
Yeah.
Yes, the district court did have jurisdiction, and I can walk you through exactly how we get there. Article 2 of the Constitution gives states great latitude in how they select presidential candidates. Under that latitude, Colorado has enacted an election code that gives district courts, including specifically in presidential primary elections like we have here, the authority to conduct the qualification disputes like we had here. So yes, the district court had jurisdiction using the authority that the Constitution gives Colorado, and Colorado, unlike many other states, has chosen to implement that authority with this pre-election challenge under Section 11113, which Section 1204 incorporates specifically, which allows for electors, voters to challenge a wrongful act or about to commit a wrongful act by the secretary. And as testimony at the hearing from Ms. Hillary Rudy indicated, the way in which that plays out in Colorado under that statutory scheme is that the secretary makes initial determinations that are easily determined. And then following this court's decision in Kuhn and Frazier, additional evidence can be brought to bear in Section 11113 proceedings that allow for the qualification dispute to be resolved.
So if I'm understanding that argument, the secretary itself, or herself in this case, could not conduct an evaluation of the constitutional qualifications of someone to go on the ballot.
No, I would disagree with that. The testimony of the practice, which was consistent, and we have the Hassan case from a few years ago, where a presidential candidate said, I am not a natural-born citizen as that is currently defined. I therefore cannot sign the attestation that's required that says I meet all qualifications. In that circumstance, the secretary sent a letter and said, it is my job to make sure that only qualified people are on the ballot in Hassan. Because you are constitutionally not qualified, you're not on the ballot. Hassan then sued, and then Judge Gorsuch on the 10th Circuit affirmed the secretary's authority and decision. Now that was under federal law, not the 1113 procedure.
And it was 2 paragraphs and not exactly a deep dive on our election code. Wouldn't you agree?
I would agree, but the core principle was not in dispute and animates the way in which our election code works to basically allow for process to occur. So it isn't just the secretary making this decision of hard to find. But as this court recognized in Frazier, even simple questions like residency can be really hard to figure out sometimes and require a lot of evidence and.
But that's
decision.
still.
my-
Oh, go ahead.
I was going to say, here's my concern. The secretary's duties under the provisions that govern presidential primaries
Mhm.
very clearly are limited to making sure that a presidential primary candidate is a bona fide candidate under party rules and has timely submitted a certificate of
Mhm.
intent.
That's a very
That
the
certificate
limit.
of intent includes the Article 2 affirmative qualifications of age, residency, and citizenship. That's it. And in the Hassan case, as you pointed out, the candidate was unable to
Mhm.
comply with that. So there's a very clear duty expressed in 1204 or 1, actually, saying that the secretary cannot certify such a candidate. Where is the duty here to examine other constitutional qualifications? Or are you instead relying on the wrongful act language to support your petition under 113?
So let me point to three authorities that may help us resolve this question and your concern, Justice Marquez. The first is that section 1.4.1201, which is the presidential primary part of the election code, says that the purpose is, the intent of the people is to conform to the requirements of federal law.
Federal law governing the conducting of presidential primary elections.
I don't think it's so limited. I think it's more general. I think that it is federal law, which includes constitutional requirements. Second, I would point to 1.4.12.033, which says that presidential primary elections must be conducted in the same manner as any other primary election, which brings in 1.4.501, which is sort of the general qualifications clause for state candidates, which certainly empowers courts to look at it.
Can I interrupt you right there? I believe your reliance on 501 actually undercuts your argument for a couple of reasons. One, the sort of boilerplate about election officials must conduct primary elections consistent with general elections. That is boilerplate that appears elsewhere in the code. And so I don't know that it has a whole lot of magic to it. It doesn't expressly incorporate 501. And more importantly, 501 is limited to state offices. So how is that connected in any way to establishing constitutional qualifications for a presidential candidate?
So two ways, Your Honor. First is so section 1.4.501 is in the state candidate section of the code. When the presidential primary section, which was passed recently, says we want to do presidential primaries sort of the same way that we do all these other primaries, our position is that that brings in the process of 1.4.501, but doesn't include the limitation in 1.4.501 because it would be silly to read that as only applying to state candidates. And the second is that Ms. Rudy's testimony at trial was that these qualifications, these constitutional qualifications, aren't just the three checkboxes. That it says on the bottom of the form, the attestation that you must file, that you meet all qualifications. Section 3 is a qualification in the Constitution that someone must check that they meet. And if the secretary certifies someone under that authority that doesn't meet all qualifications, that is a wrongful act. And that is a wrongful act that we challenge here in 1.1.1.13. I hope that addressed your question.
Mr. Olson, I want to hear, you never finished the start of your answer, and I'd like to hear all of it. You said there are three statutory provisions you're relying on. Could you please finish that answer?
Yes. So the third statutory provision is 1.4.12.03 2A, which talks about political parties putting a, quote, qualified candidate on the ballot. Now that section is directed to parties, but it requires that for a party to put a candidate on the ballot, it has to be a, quote, qualified candidate. And it is passing strange from our perspective to say that where the goal is to conform to the requirements of federal law, that we have a robust system to allow for challenges to candidate qualifications of all types.
Very true, Kelly.
exclude
Thank you for the
one
super chat.
particular qualification because it occurred in the Constitution, our most important document, rather than somewhere else.
So I'm just wondering if you can respond to the arguments made in part at the end of Professor Mueller's amicus brief, in which, for example, in looking at 1201, he talks about how the phrase governing presidential primary elections, as Justice Marcus just suggested, seems to modify both national political party rules and the requirement that Part 12 conform to the requirements of federal law. So if that's the case, does that matter from your perspective if it does?
Well, I certainly think that this court's pronouncement on how ballot qualification challenges occur in Colorado is more compelling than Professor Mueller's account. Because think of the consequences of that proposal, which is we have a system where qualification disputes occur in, as this court is well aware, nearly every election cycle, where all sorts of issues are raised. But we are cutting out a class of qualifications that are important for our most important office and saying state courts can't look at those.
Do you agree that the phrase modifies conform to the right requirements of federal law?
No, I think I disagree with that. I think
And why do you disagree? Because he points to, oh God, I'm going to actually say this, post-positive modifiers, right? And how that seemed to be an example of that. And he cites the Scalia-Garner text on reading law. Why is that mode of analysis wrong? Because it does seem to apply here to that phrase.
Well, I'm afraid that I'm not as well versed in the descriptions of the various theories of interpretation, and I would focus on two things, Justice Hood, in response. One is what I just said, which is just like in the office officer discussion you had with my colleague, it seems absurd to not allow these kind of qualification events to occur when they're an essential part of what we do. And the Constitution gives Colorado, through Article 2, such authority in figuring out how to run their elections.
Well, see, I wonder whether another answer to the question might be that it becomes a question of whether Section 3 constitutes a requirement of federal law governing presidential primary elections. And if the answer is yes, even adopting his construction, if the answer to that is yes, then the people of the state of Colorado are saying they want to see conformity with Section 3. So, I'm wondering whether the construction that he's urging is really detrimental to your case in the final analysis.
Well, it may or may not be. The national party in this case has said they can nominate an unqualified candidate. And if they have the legal authority to do that, we don't think they do, then it would be a challenge for our case if the national party rule said you can put an unqualified candidate on the ballot. We don't believe that's the case, but under their interpretation, it would be a challenge. But we think the more natural reading is that when you say conform to the requirements of federal law, that
governing presidential primary elections, right? If we were to take the party rules component out of there and just say that those other two phrases are tethered to one another, then does it really matter? And I feel
that circumstance, no. But so if that was your earlier question,
Yes,
I
this is
apologize.
very
that's what I
compelling.
was trying to say. I probably didn't say it very well.
So I don't think it matters. But again, we come back to sort of the common sense reading of our state statute of how we do this, which is to allow courts, like the district court did here, to hear the qualification disputes, even under federal law.
Well, let me ask you about that, Mr. Olson. Good afternoon to you. I'd ask you to address the intervener's argument here, and I guess this goes to prudential concerns under justiciability. You say that all the
Justiciability.
states' election officials, state secretaries have the authority to decide how to run primaries. They take the position that could create chaos. You could have 50 different states' attorneys, states' secretaries of state deciding differently, and this really needs to be national. I take that as fitting within the prudential concerns under justiciability. Can I ask you to respond to their argument?
Sure, Justice Gabriel. I think I would say three things in response. The first is most secretaries of state don't have the authority to evaluate qualifications, even the way in which Colorado does for primary elections. We saw that in the Michigan and Minnesota cases where they said their state laws, their execution of their Article 2 authority allows purely ministerial. They take the piece of paper from the party and they put that person on the ballot for the primary. Here we have a different rule. And so that leads to my second point, which is it won't lead to chaos. This is the only court in the country that has looked at this question. There are other courts where lawsuits have been filed, but as I mentioned, those lawsuits haven't proceeded. So different courts do it differently. Colorado has done it this way, and we have an opinion that's on appeal before this court. And so I think the concern of a bunch of things happening is overblown. And the third thing I would say is that the legal standards here that really matter, what does engaged in mean? What's an insurrection, et cetera, will be figured out pretty quickly if there are different approaches to that. And the answer in these ballot dispute, the ballot access dispute cases are binary. It's not that there's going to be a whole bunch of different standards floating around. There's going to be either yes or no. And so I think the concern of overblown, the concern of a patchwork is overblown, particularly when, you know, the justiciability inquiry looks at, is there a textual commitment to a coordinate branch of government?
Let me jump in for a second. I mean, that's under, if you're looking at sort of the political piece of it, right? And you're looking at Baker, but there's sort of other more prudential concerns, and perhaps that's what Justice Gabriel was asking about, and perhaps not. But can you sort of parse that out?
Sure, I would say.
So political question doctrine versus sort of broader, more general, of the type perhaps talked about in Powell.
Yeah, so I would say two things in response, Justice Birkencotter. And the first is that just because this is a politically salient question and has political consequences is the reason for the court to enforce our constitutional qualification, to honor the promise that we've made to each other in our document and say that those who engage in insurrection, no matter how popular they are not to be, having broken an oath engaging in insurrection, are not to be allowed in that position again. And so the second is that there are very easily manageable standards here, as I just mentioned. This is not a case where
Easily manageable.
A court is having to put themselves, balancing foreign policy interests and all sorts of
Except you are.
interests that are assigned to a different branch of government. This is a straightforward application of our Constitution.
So, but even if I'm persuaded on prong one and prong two of Baker, which is really what you're talking about, isn't there this other sort of prudential concern? And that goes to this idea of if you have, whether it's 50 states or 30 states or 17 states, you're going to have chaos. Can you talk more specifically about that?
So I would come back to my answer to Justice Gabriel, that the way the state laws are implement on this issue under the Article 2 authority, there simply aren't going to be very many other proceedings like this, because Colorado has chosen to implement this in a unique way. But even if there are, that's okay.
How many of these cases are there altogether?
Well,
of this sort of general type?
So there are a number of general types, but a number of them are filed by the same individual who marches into federal court. There's clearly no standing in federal court to bring these claims. So of the cases where people were prepared to actually put on evidence, there's just a handful. And this is the only one that has proceeded to the merits.
So, Mr. Olson, should we be concerned about that as we think about the Republican citizens of Colorado or unaffiliated folks who want to cast a ballot in the Republican primary? If what you're saying is correct, President Trump will be on the ballot in most states, but not here in Colorado. So effectively, the Republican or unaffiliated voter who wants to participate in the presidential primary, Republican primary, won't really be able to participate because the person who's on most ballots and appears to be leading in the primary is not an option.
So Justice Hart, I think I would say two things in response. The first is other states have different mechanisms. California allows for post-election challenges where there's an unqualified candidate on the ballot. So just because there's not a pre-election qualification dispute under state law doesn't mean there won't be a post-election one. And then secondly, Donald Trump is disqualified for the reasons that the district court found, with the one mistake of whether it applies to him. And that determination will allow for voters in Colorado to vote for qualified candidates. I would say that your hypothetical actually cuts the other way, which is we're worried about our clients who are Republicans and independents. They filed the suit because they want a fair shot in the Republican primary to vote for a qualified candidate and have their support for a qualified candidate not be diluted through votes for a candidate who will subsequently be disqualified. And so the pro-democracy, sort of the pro-Colorado voter
That's
perspective,
actually
which
not
I
a
think what
valid
we're looking at
argument
here,
that
is to
their
make
vote
sure
gets
that we
diluted.
follow the state law and
That's a
allow for
horrible
these
argument. I
qualification
wouldn't have
systems to
made that.
occur pre-election so that the ballot reflects those who are qualified and the will of the voter can be honored.
So I just wanted to take you back. Your repeated reference to
I like
qualified candidate makes me think of your third item under 141203 sub 2A, where it talks, the election code talks about qualified candidate entitled to participate in the presidential primary election. And then it ends with pursuant to this section. And I'm just wondering, from your perspective, what work, if any, pursuant to this section is doing in that sentence? Again, not to place undue significance on Professor Mueller's amicus brief, but you can remember that he suggested that that's limiting. Although as I look at 1203, it doesn't seem that there are other qualification provisions in there. We have to go to 1204 for some of that. So I'm not sure what to make of pursuant to this section.
Well, so I would read pursuant to this section as referring to sort of when and how the primary election is conducted. So they're saying the pursuant to this section says, if you have a qualified candidate, then you can be on the ballot when they're going to do it the way they say they're going to do it.
Simple as that.
Yeah,
Okay.
that's our view there. And I think, but the qualified candidate isn't limited, right? It is a qualified candidate. And so
I'm sorry, as you recognize, so that provision is really about the party's right to participate in the primary. And let's say a major party had multiple candidates, 3, say, one of which ends up being disqualified. The party could still, nevertheless, under this provision, participate in the primary.
Correct, because it is, as Your Honor focuses on, it is directed towards the party itself, but it requires that there be a qualified candidate as a necessary precondition of participation. And it to me, it's I'm sorry to cut you off.
I'm sorry. My sense is you're placing an enormous amount of weight on that single reference to qualified candidate in a provision that is not tethered to specific duties of the secretary. And I'm going to circle you back to 501 for just a moment, because by contrast, in 501, there is very rich language about the secretary's duties for state office. No person is eligible to be a candidate for office unless that person fully meets the qualifications of that office as stated in the Constitution and statutes of the state. If we had that language somewhere in 1204, I think we'd be having a very different conversation. But it's not there, and I'm still very concerned about how much you're trying to cram into the word qualified candidate.
Yeah.
So we're not solely relying on the qualified candidate language. We're talking about the general function of Part 12, which says, again, as we talked about in 1201, the goal is to conform to federal law. Then we have 12033 that says the same manner as any other primary election. Now, we believe that incorporates that same 14501 language, and the language you identified in 14501
Refers to Constitution and statutes of this state.
correct.
So-
But
Okay.
again, that limitation, when you look at the history of how the presidential primary in Colorado came to be in 2017, our view is it pretty clearly just bolted on a process for the presidential primary that carved out, as we talked about with Justice Hood, where the national party plays a role in a way that's different for state offices, which said, here are the specific changes that we're going to do, and everything else we're going to do the way we've been doing it. We incorporate,
She's
to
not
the-
buying
in
this.
12033, we do it the same way we do all these other elections. And it would be, in our view, quite astonishing to have a state election code that didn't allow for even basic efforts to see whether the candidate for president is qualified. Where you have someone who's, Hassan would come out the different way, because the answer there under the interpretation where it's only state law qualification and reference would be, hey, you're not qualified, but under state law we put you on.
Hassan would not come out the other way because the duty has the secretary has an express duty under 12041 to make sure that the person timely submits a certificate of intent, and Hassan did not submit such a statement.
Well, but it would.
You've got lots of other things to argue, and I don't mean to drag you.
We got to get through this one together. So, so what I would say,
That's a little
is
offensive to say we got to get through this together. Like you don't understand.
what we have in this case. Trump has
not the
submitted a
smartest way there.
declaration to the secretary where he has certified that he meets all qualifications to be on the ballot. And this is no different than Kuhn, where the paper said yes, but then our 11113 procedure, which is expressly adopted.
Gary, they
in
can eat up
Part
all the
12
time
of the
asking
Election Code,
questions.
allows for the court to consider additional evidence. You don't have to take the candidate's word for it.
Is that
Can
what
I-
he certified though? Oh, I'm sorry.
Go
please.
ahead. Go ahead.
No, Chief, please.
Well, let me ask a fundamental question, and maybe this is too basic, but could the Secretary of State at the very beginning of this, before the lawsuit was filed, said, President Trump doesn't meet the qualifications under the federal Constitution?
I mean, yes.
So
you-
maybe
yes.
is the answer. The reason why I
Okay,
hesitate,
well, then.
If they
okay, go
can't,
ahead.
then how
Finish your
because
answer.
because the
lawsuit work.
secretary testified that their practice has been where they know of disqualifying information or can readily ascertain it, they will disqualify a candidate. But where there's uncertainty, they will not, and allow for the 11113 process to play forward. There are no funds, there's no investigative division of the Secretary of State's office that runs around and looks at this. And so on these sort of harder questions, be they residency, what have you, the Secretary turns to the courts, and this court has recognized over and over again that that's the proper procedure for courts to make these hard questions.
Okay,
including Frazier.
but why is that? It feels like 1113 is designed to say, Secretary of State, do your job, plain and simple, right? I mean, is that too much of a simplification of that?
No, I mean, it's if you don't do your job, people can bring you to court and make you do your job.
Or if
But
there's a concern that she's going to violate a duty, an elector can bring her to court.
Yes.
Right, but do your job. So why does the court then have more authority than the secretary to then make that declaration?
Because that's the way that this court, particularly in Kuhn, has interpreted our election code in the 11113.
But we
Sounds
said
really
we wouldn't
low.
consider a constitutional question in Kuhn, right?
No,
What is that? Do we have to overrule that?
no, not at all.
Yeah,
In
you
Kuhn,
do.
there was a separate constitutional cause of action. All we are seeking here is to enforce the election code under 11113. So it is not a question of, and just like in Hassan, where the qualification at issue is a constitutional one, and particularly for federal offices, right? Those constitutional qualifications are by definition not set by the state, they're set by our federal constitution under US term limits. That is what they are. And so those proceedings occur under 113, and in Kuhn, and as the secretary's brief in this case makes clear, where a constitutional issue is the qualification, you can adjudicate that issue in a 11113 proceeding. It's not that there's a constitutional prohibition, because for some offices, that's the only qualification there can be.
So your position basically, the secretary is not bound by this one-page statement that if the secretary has information or somebody raised an issue, right? And apropos of that, the one-page document doesn't include that you've served 2 terms in office. So if the argument is the other way, President Obama could be put on the next ballot.
And Ms. Rudy testified at trial that if George Bush or President Obama were to submit an application and sign it, that would be, they would not put them on the ballot, because that is a readily ascertainable constitutional qualification that they don't meet.
And let me ask you if I can, you got 11 minutes left and I know you want to save time for rebuttal. Can we get to the merits issues? So,
Sure.
And I'll start you off, and I guess I'll express a concern about the definition of insurrection that the district court adopted. It strikes me as somewhat or potentially overbroad. So let me ask you to address that.
Well, I think the definition, the one to focus on is there's two definitions in there. In paragraph 240 is the one that applies here because it's insurrection against the Constitution. And it was a public use of force or threat of force by a group of people to hinder or prevent execution of the Constitution of the United States.
Well, I'll give you a hypothetical why I'm concerned. Say someone, God forbid, makes a threat to two people get together and make a threat to a judge. That if you go forward with this proceeding, I'm going to do harm to the judge. Under the court's definition, that's arguably an insurrection. It's a group of people getting together to act against the Constitution, preventing a constitutional duty. You have to take a federal judge. I don't think you would say that's an insurrection.
Correct. I would not say that's an insurrection. And the reason why is because the public use of force or threat of force has a very specific meaning, which is for public purpose or for public end. So for more than just your purpose, right? If you're going after a particular judge for dissatisfaction, but it's a public in that we're advocating on behalf of the public using this violence for a public end, just like we saw on January 6th.
Let me stretch my hypothetical a little. Say the person is expressing concern the judge is too liberal or too conservative. Public expression. I don't like the judge's politics, so I'm going to take that action.
That would not be for public purpose or public ends under this definition. It really requires, as we saw here, and as the testimony of Professor Magliocca at trial talked about the historical understanding of insurrection, that there has to be a real public use of force to hinder or prevent the execution of the Constitution of the United States. And here, there can be no doubt that trying to disrupt the peaceful transfer of power by stopping the counting of the electoral votes is hindering the execution of the Constitution.
The distinction then is that there's an attack on the authority of the government, even if it's not an effort necessarily to overthrow the government. Is that what I hear you saying?
Yes, because an effort here to delay, use violence to delay the count would be an insurrection.
And I know you want to save time, but just very summarily, do you see much distance, if any, between the argument that you're making that the district court adopted and the argument that is set forth in the Bode-Paulson article? Is that, I mean, they use slightly different words, but they seem to sort of deliver a very similar message in my estimation. Is that fair?
That is fair. But I think what is crystal clear
Right.
is that what happened on January 6th easily satisfies either definition.
So let's not get lost in the weeds on the test.
Let's not get lost in the weeds.
Yeah.
And I do want to save time for rebuttal. I want to make sure I answer the court's questions as well. But if I could end on a final comment and then come back for rebuttal, which is that our Constitution, as we've talked about, is just a document. It's a promise to each other that we must enforce to protect our shared democracy. In committing ourselves to that Constitution, the rule of law comes with real fragility because our Constitution commands no armies, it has no police force. All it has is very limited self-defense mechanisms that my colleague mentioned, and that is Section 3. And all Section 3 says that if you take an oath to support the Constitution and then turn around and attack the Constitution, you cannot be trusted to take an oath a second time because you've shown yourself unworthy and incapable of ensuring that we remain a nation ruled by law rather than by one man. Qualifications by their very definition limit who can vote or who can run for office. And Trump's argument
we're
that
saying we
because
can
he's
limit the
popular,
vote.
that should affect how we interpret Section 3 here could not be more dangerous. Jefferson Davis would have gotten a lot of popular support right after the Civil War. And the application of Section 3 is
Except
at
for the
its
rest of
most
the Union.
urgent when a person who has desecrated their oath to the Constitution already seeks to become our commander-in-chief again. If we say that this conduct
Guys, I got to be right back. I got to pay the
by
bill.
this person is not enough under the Constitution, what we do is empower Trump and others to use more political violence to attack our democracy. Enforcing our Constitution enables the will of the people, and we must enforce it against unlikely candidates like Hassan and popular candidates like Trump. I'd like to reserve the rest of my time for rebuttal, but we ask that you reverse the district court's finding that Section 3 does not apply to Trump and affirm in all other respects.
Mr. Olson, before you sit, I have a question. The grounds for disqualification here obviously have to do with Section 3. And I worry about the fact that Section 3 itself doesn't have an enforcement mechanism. And so here you're saying, well, Colorado state law allows us to enforce it in a way. And you said California has a system. Do we want an approach where each state decides on their own what Section 3 means or how it should apply? And then those states that don't have a law like Colorado are not able to do anything about it. I worry about that. Can you address that concern?
Sure, Justice Samore. I would build on my answer, I think, to Justice Birkencotter earlier. And if I may have a couple minutes for rebuttal, even if it takes a little longer, Justice Boatwright. I think I'd focus on two things, which is particularly for the presidency, where Article 2 gives sweeping authority, as the Supreme Court just said in Chiafalo and Baca a couple years ago, for states to determine how to do it. There is going to be some uncertainty. Some states used to use legislators to pick their presidential electors instead of a popular vote. So some uncertainty is built into the system. And then I would say the second piece is that the legal standards that apply here under the Supremacy Clause of what engage insurrection means will be uniform. It may take a little bit to get there, but there is a mechanism to ensure that uniformity. And so there's no need to worry that there's going to be 50 different approaches to this issue. There's going to be one approach here. Maybe another state will do it, maybe they won't. But there's not an overwhelming indication that there's going to be 50 different approaches here. And
Yes,
the last
there
thing I'll
is.
say
You're
even
literally
if
saying
that
each
was the
state can do
case,
this. We
that's
could
the
have
nature
50
of a
different.
federalist system like we have. The states have broad authority, particularly where there's a specific allocation of responsibility under the Constitution.
Which means there can be 50
in our existing
separate ones.
mechanisms, the courts, the Congress, the US Supreme Court have shown their ability to keep those concerns from overwhelming the issue. So that's what I would say to that question.
You may reserve the remainder of your time.
Thank you,
Thank
Chief
you,
Justice.
Mr. Olson. Mr. Gessler, when you're ready.
That literally
That was a very
means you can
steady
have
pour.
50 separate arguments.
Impressive.
Holy
I'm
cow.
going to need that water, I think, Your Honor. Members of the court, thank you very much for your attention here today. Again, my name is Scott Gessler, representing President Trump in this matter. Time permitting, this is a big case. I'll try to talk about why this court should not exercise jurisdiction under 113 and 1204 under the principles set forth in Frazier versus Williams and Kuhn versus Williams. I'd like to talk about the textual structure, the officer of the United States, the office under the United States, and the oath, the textual structure. And time permitting, I'd like to talk about the issue, the legal standard of engagement, and of course, insurrection as well that have been asked, and then perhaps get to the infirmities of the court using the January 6th report. I know there's a lot. Please feel free to interrupt me and move from one section as members of the court see
Just
fit.
before you dive in, I did not hear political question doctrine on that list. So
I
is that by
put that
intent?
under the category of enforcement
Okay,
here,
thank you.
broader federal enforcement. So we sort of view, when you talk about self-execution, preemption, political question, they are sort of intertwined with some of the same considerations, in part because of the difficulties of applying consistent standards, which ties into the fact that Section 5 of the 14th Amendment creates a specific enforcement authority to Congress, which was recognized in the Griffin's case here. So that does sort of talk about the justiciability. I can dive into that section if
Let's
you want
start
right now.
there.
I'm sorry?
Let's start there.
Okay. Your Honor, so enforcement is the proper framework. And this is a non-justiciable question. And there are prudential concerns that 3,000 different state jurisdictions will approach this in different ways. Now, I understand that the petitioners have said, well, that's okay. Under Article 2 powers, states can do whatever they want. Well, that's not true. States can't do whatever they want under the Article 2 powers. There are still nonetheless constitutional mandates. For example, in petitions, states have to behave a certain way, as in Anderson versus Celebrezzi, for presidential candidates. And in fact, in Anderson versus Celebrezzi, the court said that the state interests are lessened when it comes to a presidential candidate. An invocation of Article 2 powers to choose presidential electors, that's not an enforcement mechanism in the sense of a judicial enforcement following a law. It's a political process, and it's a value decision. The people of the state of Colorado could, for example, if they amended Section 20 of the Schedule Constitution, that requires allocation of electors by popular vote. But if they amended that, they could say, we don't want anyone with gray hair. We don't want anyone over 5'2". Okay, they can create those through political value decisions. That's not an enforcement mechanism of Section 3.
Well, let me just ask you directly about that to go right to the point. Obviously, you focus on Section 5, and it says, it gives authority to Congress to enforce the 14th Amendment. It doesn't say exclusive authority, but my concern is this. If we have to rely on that as the enforcement mechanism and the 14th Amendment is not self-executing, then the Due Process Clause and the Equal Protection Clause are not self-executing. So Congress could nullify both of those by doing nothing and taking no action. That's concerning. The 13th Amendment has the same language. I don't think anyone would say that Congress needs to act to enforce the abolition of slavery. So help me understand how do we get to self-executing here?
So I think Justice Chase would disagree with that characterization with respect to the consequences. In the Griffin's case, which I think was discussed at length in Professor Tillman's amicus brief, Justice Chase basically created sort of the sword versus shield distinction, that in the Jefferson Davis case. And in the Griffin's case, he said that, I think he did use the word executing, that the Section 3 does not execute itself. In fact, it requires implementing legislation. Now, that was from a Chief Justice of the U.S. Supreme Court. I recognize he was riding circuit in Virginia. But Congress then almost immediately did what he suggested or what he demanded to be done. In other words, it passed the Enforcement Act. That's consistent.
But sorry to interrupt, Mr. Gessler, to come back, I guess, to Justice Gabriel's question. The fact that Congress passed one form of enforcement legislation doesn't mean that there might not be other ways that that Section 3 comes into play. They didn't cover the field.
Well, that's fair standing on its own. But in response, we still have Justice Chase's decision in the Griffin's case. And remember, Justice Chase took a very muscular view of use of the 14th Amendment. He dissented in the slaughterhouse cases and specifically decried the limitation, the privileges and immunities portion of Amendment 14. So, but when you look at Section 5 of the 14th Amendment, why do we even need that? Well, Congress thought we needed it. Congress thought the framers thought we needed it. They thought they needed it in order to grant Congress that authority. They didn't grant the states authority. Now, one can say, well, that means nothing. But actually, if you look at the 14th Amendment, the whole purpose of the 14th Amendment was to limit states' authority. It would be very counterintuitive otherwise. Yes, ma'am.
Yeah, so can you point us, though, to sort of that, the textually demonstrative constitutional commitment? I think, as I understand your argument, you're sort of asking us to look at the gestalt, right? You want us to look at the whole, these four separate parts of the Constitution, and sort of stitch them together and say, look at that in terms of this first prong of Baker. And is that correct? Can you point me to something specific?
So with respect to the four prongs of the Constitution, you're referring to?
Your argument with respect to how this is, how we are foreclosed under the political question doctrine. Sorry, I'm pivoting around here.
No problem here. Well, I think there's a couple reasons. One is the prudential reason that had been discussed, which is a multiplicity of different states. The petitioners mentioned that California does a post-election opportunity for attack. So that may be one way. New Hampshire has said that despite the Hassan case, they had the exact same situation as in Colorado. They don't have the authority. So you do have a patchwork where voters are going to be treated differently and affected across the country. And that is somewhat chaotic.
Isn't part of the answer to that, if we were to say that President Trump can't be on the ballot here, there's a very high probability that the United States Supreme Court would step in and decide what the standard should be, one would think. So there wouldn't be the same potential for the chaos that you're describing. Is that not a fair response?
Well, President Trump would certainly think that, yes, we would want to appeal it. But I don't think that the court should rely upon the hope that the U.S. Supreme Court will step in. The standard is we should look at that in advance and prevent that bad situation from occurring in the first place. Those are the prudential concerns.
But let me pick up on, and really the point you made, which was we have this today. We haven't had chaos in well over 200 years. I mean, states have these authorities. California has one mechanism, New Hampshire has a different one. I'm not so sure that we have the crisis that you might suggest.
We're facing
Those
a crisis.
mechanisms
This
are
is different.
procedures. They're not the substantive application of Section 3. There is a difference there. When we talk about procedures, yes, New Hampshire has a different set of laws for qualification than Colorado. But those are all different procedures.
Well, let
They're
me
not
ask
the
Colorado.
substantive application of a disqualification standard.
Forgive me, Mr. Gessler, so let me ask you about that. So can the Secretary of State disqualify a candidate who is not born in the United States?
That's a question. I don't think there's a statutory authority for them to do that. Now the petitioner has said, well, Hillary Rudy testified to this and that, and deep respect for her, but that doesn't define what a state's authority is. We have 1204, which requires a statement of intent. And the question is the form for 1204, does that carry the force of law? That's really sort of the question.
Well, it's a
So-
constitutional qualification. That's why I was asking the question. I mean, there's some suggestion that we should look at different qualifications differently. The 35-year age limit and the born in the United States are one thing, but
Well, if
you
you're
know,
a U.S. citizen,
the
natural born
14th
citizen,
Amendment is
you can be
something
born
different.
outside
That's
the
what I was
US, so-
asking.
Right. First of all, I'd say the 14th Amendment's not a qualification. It is a disqualification. And in fact, if we even look back to McKee's original introduction of that legislation, that talked about qualification and holding, whereas Section 3 only talks about holding. So I would probably not concede the point on qualifications.
So actually, to that, and I know we're going back and forth between political question and I suppose the question of whether Section 3 is self-executing. But as you say, it's a disqualification. The only thing that the 14th Amendment says that Congress can do is remove the disqualification. Doesn't that suggest that the disqualification attaches independent of any act of Congress? Otherwise, they'd have nothing to remove. Did they have to say that Jefferson Davis met the definition of an insurrectionist under the 14th Amendment?
Well, you have to.
I would
ascertain it.
disagree that Section 3, that last clause, can't be read in isolation from Section 5 enabling legislation. And the Section 3 congressional action is more akin to the powers of a presidential pardon. It's essentially a pardon mechanism. And I don't think one can draw the inference that forecloses or affects the substantive law that allows that disability to come into effect. You look quizzical, Your Honor.
I am in fact quizzical.
So-
Go ahead.
May I
Justice,
jump in?
yeah.
Justice Gabriel, were you done? with
Go ahead.
Yeah. So you mentioned these prudential considerations and, let's avoid chaos. One of the counter arguments is that by failing to resolve this issue on the merits now, we create the potential for chaos in January of 2025.
Mhm.
And so there's much emphasis on this in the scholarly literature about how it may be better for us to try to resolve it sooner rather than leave the potential for a constitutional crisis after the next presidential election. What's your response to that?
The response is not if we follow what I call the rule of democracy, what Attorney General Stanbury said in a couple instances, that when there's uncertainty, the disqualification doesn't apply. Ultimately, if the Republican Party chooses to take that risk, and Republican and unaffiliated voters in the state of Colorado choose to make that choice, that is their choice. It should not be foreclosed from this court.
Well,
There are-
what do we do about Timmons then? Where in the,
I'm sorry, Your Honor.
what do we do about Timmons, where the U.S. Supreme Court says there's no absolute right to put someone who's not qualified on the ballot?
I
And
would.
we're talking about a political party here.
Right. And I agree that there aren't absolute
That's a fair
rights.
question.
But there's certainly at a minimum an ambiguity here. We don't think so on with respect to our approach. But the Timmons and the Wisconsin ex rel Follett cases nonetheless stand for political party First Amendment rights. That even if state law, for example, in the Wisconsin case, even if state law mandates one thing on how to assign delegates, state party rules prevail.
So your view is, then I would take it, that if either party wants to put on, we'll say President Obama, or someone who's 20 years old, or Arnold Schwarzenegger, they have every right to do that.
Conceivably, yes. Now,
Wait, you say
can you- yeah,
conceivably, what do you
yeah.
mean conceivably?
Well,
Do they or don't they?
I was about to go forward. Look, I mean, Hillary Rudy testified, and it's not unreasonable, her testimony. And she said, look, the secretary can be involved in using the form for the 3 Article 2 qualifications, if it's an objective, knowable fact.
So then if it's a fact question, the secretary can. So if there's a question about whether the person was born in this, was or was not born in this country, the secretary can't act. But if it's objectively, nobody doubts it, then the secretary can. That's a tough standard.
I agree. That was her testimony, and that was her escape valve when pressed on that issue.
But what is your take then on 1204 and the ability of an elector to challenge, let's say, the Obama example, where the 22nd Amendment would prohibit him from serving because it limits a person from serving more than 2 terms as president. So let's say President Obama wants to be on the Democratic Party primary ticket, checks all the boxes, unlike Hassan, checks all the boxes, tenders the statement of intent. Can an elector challenge his qualification under 1204? And if not, why not?
I would say no. First of all, from a broader constitutional preemption, justiciability question, Article 2 doesn't quite face the same self-execution issues. The courts are split, but the weight of authority has been, because those cases were litigated, the weight of authority with respect to President Obama, Senator Cruz, and Senator McCain, all of whom were challenged on natural-born citizenship. The weight of authority is that states do not have the authority to be able to consider that. That's
Does it
the
matter
weight.
that most of those were decided after the person was elected into office? Does that matter?
Not in that aspect, Your Honor. It does matter because we would submit, and we have said before, that this court should have never exercised jurisdiction because of the complexity of the issues, the truncated procedures, and the inappropriateness of the 113 in this instance. So I think that was more of a function of the time, and they weren't considered moot because they were capable of repetition.
What does
So I don't
1204
think that matters, though.
Sorry. What does 1204 do then? What can you challenge under 1204 for?
1204, let me step back. Remember, 1204 mandates a hearing within 5 days of the petition, and it mandates a decision within 48 hours. So, and it specifically refers to Section 113, which requires a duty under the code. So that, with that structure in mind, 1204, the very structure of 1204 contemplates a very limited proceeding. And the limited proceeding is set forth in the substantive provisions of 1204, I believe it's 1 and 3. So for example, there has to be a certificate from the state party saying that the candidate's a bona fide candidate. The candidate has to be affiliated with a party that had received at least 20% of the vote. The candidate has to fill out a statement of intent. Questions as to exactly what the content of that statement of intent is required. There's no rule or regulation that the secretary's promulgated. It's merely a form which, according to Hillary Rudy's testimony, never went through the process. It was created by people within the office and reviewed by their legal counsel, and that was it. But those are very limited requirements. And under 113, there is not a duty. So to the question, if I may use that to transition a little bit to the 113 jurisdictional issues, could the Secretary of State simply said, I hereby make the determination. I think it's an obvious knowable fact, as she has said on TV. It's an obvious knowable fact. President Trump engaged in insurrection, therefore I keep him off the ballot. Let's say she said that. Does she have the authority to do that? think the answer is no. She admitted she doesn't have the explicit authority to do it.
So how
I think the
do
court
we-
correctly recognized it.
I
Yes, sir.
apologize, Mr. Gessler. I guess I just keep wondering, well, then what are we supposed to do, right? So there has to be some mechanism for review, doesn't there? And under your interpretation of things, is there really any?
To the extent, the way this would work would be the way Frazier suggested. And I didn't disagree. I didn't agree with Frazier, and I don't think you did either, Justice Gabriel. But I think this case proves the correctness of Frazier, although I hate to admit it after 20 years of litigating this very issue. What the person would need to do would be file a declaratory judgment action outside of 113 to enforce the 14th Amendment.
Would the deck action be in federal court where there's a likelihood that the person wouldn't have Article 3 standing?
Funny you asked that,
Yeah.
because it was brought in this very
Probably.
case.
Oh.
Remember, there were two
Probably.
counts in the petition.
Right.
One was a 113/1204, and the other was a deck action. We removed it, snap removal to federal court. The petitioner said, no, you can't do that because we have no concrete or particularized basis. So it has to be in state court. There's no federal jurisdiction. So it gets bounced back to state court. Then what we do is we say, well, you don't get the deck action either because those are the same standards Colorado follows. After which the petitioners say, well, you're wrong, but we're still going to remove it in order to streamline the proceedings, which weren't streamlined because we litigated the entire constitutional issue nonetheless. But the
Coming
deck
back
action
to-
would be
right.
the proper approach.
Mhm.
The deck action would be the proper approach, and they would be required to meet the standing requirements as other litigants have across the country and these other issues in a, at most, preliminary injunction context, but also affording time to properly litigate them.
I guess what I'm looking for ultimately is a meaningful opportunity for review. And that doesn't seem like one, at least, and maybe the history of this case demonstrates as much. So are we just stuck, I guess is the question?
No, I would say it's completely a meaningful opportunity review. And look at Kuhn, okay, Kuhn versus Williams. If you remember, that was a residency issue. This court bounced there were two issues brought. One was a constitutional saying that the residency requirements are unconstitutional. This court bounced it, saying you can't bring a constitutional claim. Appropriate under Frazier. So what did the petitioners do? They immediately went to federal court in that case. And Judge Blackmun in federal court said, you're right, they're unconstitutional. So there was adequate time for review of that constitutional issue in federal court. That was done under a preliminary injunction context. So they required a heightened standard of review. But that procedure has worked and worked fine.
Let me ask you, Mr. Kessler, you rely a lot on Kuhn and Frazier. Do you not see those as distinguishable from this case? In those cases, there was a 113 action and there was a 1983 proceeding challenging the constitutionality of the residence requirement. That was a separate claim, not within the 113. Isn't that different than here? You say here the 113 action was a constitutional claim. Do you not see those as different?
No, I don't think this was an independent claim as well. Look, I mean, this was dressed up as a 113 and a 1204 action.
But let me push back on you a little bit, if I may. So if there was a 113 challenging the qualification of, whether you're a citizen of born in this country or whether you're 35, I think you'd say that fits within 113. So if this is, and I understand you disagree that this is a qualification here, but let's say hypothetically we disagreed, that would fit within 113. I think the other side would say this was an issue about whether President Trump was qualified.
I think you'd have to look at the nature of the litigation itself. Okay, so I would use 2 or 3 different frameworks. Let's put the shoe on the other foot.
That's a fair question to ask.
Secretary rejects in an administrative basis. President Trump then has to sue. What do we sue under? We would sue under the 14th Amendment, and we would sue under the First Amendment, the Brandenburg Standard, saying he didn't engage in anything that incited violence. I'm sure the secretary, properly so under Frazier, would say, no, you're challenging governmental action. You're challenging my action under the Constitution. You can't do that under the election code. You have to do it in a declaratory judgment action. Now, here it's reversed, but it's the same concept.
Why
And
wouldn't
the
you therefore bring it under 113? I guess, why would you start with a losing argument? I'm confused by that. There are lots of kinds of actions where the primary thing that's litigated isn't the underlying basis for the suit. I think about any kind of malpractice case. The vast majority of a malpractice case might actually be the underlying claim, like a legal malpractice case, the claim that was lost. But it's still a legal malpractice case. It's just that you spend most of your time talking about whether you lost the claim that you could have had. So the fact that a lot of ink was spilled and words were spilled on the Constitution doesn't make it a constitutional claim.
The mere fact, I would agree with that.
Good
However,
point.
I think this differs, that this was in fact a constitutional claim. This whole thing is about constitutional litigation. There's no, look, the court recognized there's not a duty for the Secretary of State to investigate or consider disqualification under the 14th Amendment. The Secretary of State herself explicitly said there's no explicit
And I don't think
authority.
they're arguing that in the duty part of the language. I think I understand them to be saying if the secretary were to put President Trump's name on the primary ballot, that would be a wrongful act because the former president, is not qualified to be on the primary ballot. So it's not an argument of dereliction of duty. It's an argument about a wrongful act. And under Kuhn, they're arguing we can look at other evidence that she might not look at.
I think Frazier answers the other wrongful act and rejected that expansive interpretation. And specifically, Frazier said the problem with that is that there's no limiting principle. I say that because I made that argument and it did not succeed. And I will be honest, I think it's proper looking, because in large part, the Secretary of State said these expedited proceedings are wholly inappropriate for something beyond the election code because of the complexity of them and the incompatibility with this. And this is exactly, I think, what happened in this case, where we were denied all discovery, no initial disclosures, no opportunities for depositions, a limited time frame of 6 weeks to prepare our case from nuts to bolts to contend with 400 conclusions within the January 6th report, which became 100, which ultimately became 31. So there were a lot of infirmities in these procedures, and that was first and foremost, I would submit, in the Frazier court's mind. Justice Gabriel in his dissent said, well, that can be and should be resolved with respect to a management order, a case management order in the trial court below. I think that optimism was probably misplaced as proven by this particular case. So this was in fact, in substance and in consequence, constitutional litigation. This was not a duty under the election code, which is what 113 requires. The reason why 113 has expedited procedures, the reason why they are appropriate and tolerated and endorsed in the election context is because they are generally simple, straightforward duties that don't involve complex constitutional litigation.
So is the rule that the secretary has authority if it's simple and not complex, but doesn't if there is? I mean, hard to articulate a standard like that.
Yeah, that is.
I think the standard is the constitutional standard. To be sure, a residency requirement like the type that was litigated in Kuhn can be complex.
Mhm.
But it's not
And it's
complex
not.
like this, and it's not complex like a constitutional issue, and it doesn't carry with it the same consequences, oftentimes, the precedential consequences as well.
So
And I appreciate-
complex and complicated is what I'm hearing the standard is.
Well, constitutional,
Yeah.
because the Frazier court properly equated that, but the Frazier
Well, I
court,
heard your answer to Justice Hart. In
Okay.
terms of
you're
yeah,
teasing
how-
me, Your Honor.
I am teasing you.
Uh,
Yes.
I'll take the teasing.
So what
Mr.
about-
Gesson, let me
go ahead.
okay, let me take it, and your time is so short, and I know you want to get to the merits, but while we're going through all the jurisdictional boxes here, let me take you to the whether the president is included in the 14th Amendment. And I'll ask you just a specific question. I'm a little surprised to not have heard on the intervener side and the amici on your side a real full-throated response to the absurdity doctrine argument. I mean, there's an argument here, and I'd like you to respond to it. How is it not, and I'm not making fun of any of this, how is it not absurd to say anybody who engaged in insurrection can't serve in office except the president or a former president or a vice president or a former president? How is that not absurd?
So the absurdity doctrine requires, and looking at sort of the Scalia-Garner definition, which is as probably the best out there, it has to sort of be beyond reason. It couldn't even be reasonable for the framers to take that approach. And here's the approach the framers took, and we have to look at the historical context as well. They said the presidency, remember, it's office under the United States, officer of the United States. So we're talking office under the United States, is protected through presidential electors. through presidential electors. So that's one protection. The second protection
But
was,
I'm sorry to interrupt before you go into the second, but do you really think the framers took a whole lot of comfort in the fact that the electors are going to protect us from an insurrectionist former president like a Jefferson Davis?
yes, and that's why they included them.
So
That's why they include, but let me finish, if I may, for my other two
by all
points.
means.
They
sure.
also looked at the freedmen, former slaves who could now vote. And then they also looked at the electoral strength that the northern states had to provide comfort. It's perfectly reasonable in this context. And by the way, they were right. They were right for 100 years. It wasn't 100 years until a Southerner got elected. Now, I'm not saying Jimmy Carter was an insurrectionist by any means, but before you even had a Southerner elected. So not only was it not absurd, but their framework and approach was successful. It was very successful. And when you look at the actual language, look, if you look at the structure of the text, it is harmonious. It was very carefully drafted, and every indicator points towards excluding the presidency and the president. Officer of the United States is used in 4 different contexts of the United States Constitution, every one of them which excludes, properly viewed, the president. The appointment clause, of course, there's been a lot of discussion on.
And so fair enough. So what is it does also refer to repeatedly the office of the president and the like. What
Office
is,
under the United States, officer
but I'm-
of the United
but when it
States.
talks about the president,
Yes,
it
sir.
describes that as an office.
Correct.
What, so the president is an officer. What is the president an officer of?
So the, if I can find my notes quick enough, the analysis that has been found is that the president is an officer of, to the extent we have that concept of the Constitution. So an office under the United States is one created by the United States government. An officer of the United States is one that serves the United States government. And there's precedent that says, look, senators, representatives, and the president, they are the government. That's sort of the reasonable, the analysis, the distinction. And look, opposing counsel pointed to the emoluments clause as absurd. How could you possibly believe a president would not be part of the emoluments clause? Well, I would suggest you walk into Mount Vernon and you will see above the fireplace a full-length portrait of King Louis the 16th that was given to George Washington by the French government. And no one batted an eye. It was never viewed as a violation of the emoluments clause because no one thought that it applied to George Washington. There's also the key to the Bastille that was given by a representative of the French government.
We've got enough on our
Lafayette.
hands without emoluments, right? So,
But I wanted to point out the structural point that it's all consistent with the president not being
Well,
part.
let me just harken back to something that was said by opposing counsel, and that is, maybe we shouldn't be so quick to attribute significance to what the framers did with Article 2, Article 6, given that we're talking about framing and ratification that occurred during the Restoration. So maybe it's part of the puzzle, but is it really all that illuminating when we're talking about 80 years difference? And shouldn't we be looking to other sources given that amount of time?
I think it's very illuminating, Your Honor. I mean, the one thing I think everyone would agree on would be that the framers of the original Constitution, like the drafters of the 14th Amendment, spent lots of time thinking a lot of deep thoughts about the exact language that should be used. And I think we should all assume that those words were chosen with care. And the words in Section 3, in multiple ways, mimic the exact language of the underlying Constitution. Officer of the United States. They use that phrase exactly. They use office under the United States. They don't use officer under the United States. No one ever uses that language. It's office under the United States, officer of the United States. The oath. So here's an important point I would make. Petitioners say, well, they're synonymous, doesn't matter. They really sort of include the same. But if you think about what actually happened with the framers, they have before them a United States Constitution, the original Constitution. the drafters of the 14th Amendment. And there are 2 oaths, one that clearly applies to the president and one that clearly applies to appointed officers.
Although, as Justice Marcus pointed out, there's no language under Article 6. It just says swear an oath.
An oath.
There is language. The language says to support. Now, People interpret it differently, but that's the language of the Constitution. And my point is this: the drafters of the 14th Amendment said, what oath am I going to choose? They chose the Article 6 oath. Remember, they had before them choices. They could choose the Article 6 oath. They could choose the Article 6 and the Article 2 oath. They could choose neither oaths, or they could choose both of them. They chose one and one only, the one that did not include
The one
was
that
different.
covered everybody. I think that's also, it seems to make no sense to me. I'm going to circle back to the absurdity argument that if the purpose of Section 3 was to punish oath breakers, that you would set up a provision that punishes those who break the lesser oath, but exempts persons who break the arguably more serious oath to preserve, protect, and defend. What is the rationale for that type of exclusion?
Is it a lesser oath versus a more stringent oath? I think that's a presumption we're making that may or may not be warranted because there's not much case law
Can you,
defining the two.
so can
my
you make
point-
the argument that an oath to support is stronger than an oath to preserve, protect, and defend the
Yes.
Constitution?
Preserve, protect, and defend are specific words, specific actions. Support is a general category and far broader.
And the
Support can mean all kinds of things, as
Like
shown.
preserve, protect, and defend.
Can mean that, but it can mean other things. Or it could be viewed as narrower. The
Or-
preserve, protect, and defend are very strong charges, and support is to help those who preserve and protect.
And so the
and
logical
defend.
consequence of that, though, is that the president doesn't have a duty to support. I mean, that's your argument, right?
Now, my argument is this. My argument is that the drafters chose specific language. And the language they chose was language that the underlying United States Constitution treated as separate things. We can argue about whether the underlying Constitution should have treated them as separate things. We can argue about whether functionally they should or should not be separate
Well,
things.
I
but the
you're- I
drafters
think
of the
we're
14th
asking
Amendment
you
made a
about-
choice.
I think that what we're asking about is the meaning, and what you're arguing about is the meaning. And what I hear you saying is support is a lesser standard.
No, what I'm saying is this. I'm saying the meaning is that the
Yeah, that's
drafters chose to exclude the United States, the presidency by using specific language. I'm sorry, the president, the officer of the United States. My point is the drafters made a choice to exclude
Why?
by choosing the support oath language, which mimics exactly Article 6, which applies to appointed officers. And they did not choose the Article 2, which applies to the president.
And I guess I found, I read a lot of briefing over the last couple of weeks. I saw no rational reason for that type of an exclusion.
The historical record is devoid of that discussion. We can make it up here. We can come up with ideas.
We have a lot of historical evidence to the contrary, suggesting everybody thought that it did include Jefferson Davis.
I would
or
suggest
someone.
that there's a real paucity of evidence. When you actually analyze the citations made by the petitioners, it comes down to roughly one or maybe two newspaper articles during the entire ratification debates. I would not concede that point, Your Honor. I do not.
Can you come up with a rational basis for excluding either the office of the presidency or someone who swore an oath as a president
I think
from the Section 3 disqualification?
the answer is yes. And I think the drafters, they rejected McKee's draft. They removed the presidency, the president, and they added presidential electors in. And
I
that was the
understand the
mechanism.
textual argument. I'm trying to understand the basis, the rationale. Why?
I think that is the rational argument.
The rationale, not the rational. With an E, rationale.
I think that is the rationale, Your Honor. I just do. I think that's what we need to accept, is that the framers, the drafters of Section 14 made those choices in that era, and it's not absurd because it worked.
So the choice you're saying is that they chose to include the electors instead of the president.
Yes.
But to accomplish the same purpose, in other words, the electors, if this worked as designed, would prevent anyone from in that situation from assuming the office.
Well-
So why go about it indirectly when you could just go about it directly?
I guess we go into a more, I don't want to use the word metaphysical, but a more abstract argument is, if the entire nation chooses someone to be president, Can that be an insurrection, or is that democratic choice? Remember, the president is a little bit
I'm
different.
at my office.
Everyone in the country has an opportunity, or should have an
I don't-
opportunity to vote for that person.
Oh, go ahead.
I don't think anyone here is suggesting, and I don't take the petitioners to have been arguing that the election of a person as president is an insurrection. I think that what the insurrection might have been is a different question. So I'm not sure where you're going with that argument.
I'm going with the broader context of the president is different. And if everyone in the country chooses a particular person as a president,
So if everyone chose an insurrectionist, look, Jefferson Davis, let's use that example. If Jefferson Davis ran a while ago, and the electors who were not themselves insurrectionists chose to put him into the presidency, that would be fine under Section 3, and that would be consistent with the purposes of Section 3.
that would be the rule of democracy in work.
But the
Yes.
rule of
And could-
democracy, there are limits. I mean, the president can't be under 35 or can't be, someone who wasn't born in this country. So you could, I mean, the argument, that if you take your argument to the limit, it would say we can elect Governor Schwarzenegger or, my 27-year-old kid.
I don't think it goes that far. It's that rule embodied in the text of Section 3. Now, there are plenty of anti-majoritarian measures in the structural constitution. And there are these qualifications. No one argues that. But when we're interpreting Section 3 of the 14th Amendment, and we look at the history behind that and the context and the language they used to satisfy the conditions of Section 3, you have to be under the United States. You have to hold the office under the United States, and you have to be an officer under the United States, and you have to take an oath. You have to have all four of those items in place. Any one of them, Section 3 does not apply.
Stepping away from Article 3, though, for a second, and sticking with the Constitution, could the Democratic Party put President Obama up on the primary ballot? Could that happen?
I haven't done a full analysis of that particular provision, Your Honor. I'm really sort of focused more on Section 3, but could they do it? Conceivably, I think it's an open question. If you look at the political question analysis of the Article 2 courts, the weight of authority was that states could not prevent that.
If
So
I understand your democratic process argument, that would seem to be the logical conclusion. I'm just trying to make sure I understand the breadth.
the breadth is confined to Section 3, Your Honor.
But stepping away, because you were focused also on the Constitution.
Look, I'm focused on the structural constitution to look at the language. Officer of the United States is used 4 times in the structural constitution. And each time it does not apply to the US president.
Go ahead.
I mean, not once does it apply.
No, I know.
Officer of.
You didn't answer my question, but that's okay. I'm not gonna, I want to let you use your time the way you want to use your time.
So I feel like we're
Please
going,
feel free to take another run at me, Your Honor. I do want to be responsive. Yes, sir.
I feel like we're going in circles to some extent right now. I'm just wondering if we could shift gears. I was hoping to talk about the First Amendment and Brandenburg. Obviously, you've briefed at length the assertion that President Trump did not advocate violence in his speech on the ellipse. And so the counter argument to that is that we have to look at context, and they assert that we should, well, the trial court obviously did place a lot of reliance on Professor Simi's testimony and coded language. I'm just wondering if you can give us your perspective on the extent to which precedent allows for that kind of analysis. I struggle with what I see as a lack of precedent on that particular issue, how far context goes. What's your take?
Context plays limited and probably almost no role. Now, look, this isn't a case, the incitement, and obviously we contest that incitement is part of engage. Happy to address that as well. But this isn't an instance of sort of planning, joint planning, or a joint agreement where President Trump had specific conversations, a back and forth. That's not what this is about. It's about inciting based on his public speech. That's what it's about.
So in saying that, I apologize for interrupting, but are you saying just look at January 6th and nothing else?
I will look at both, but to meet the imminence standard under the Brandenburg analysis, you have to look at just January 6th. That's really what you have to look at. And if you look at January 6th, his speech said, "Go peacefully and patriotically." He made 2 tweets followed by a video during the subsequent 3 hours.
But he also said probably 20 times fight.
He said it once, and he said, I was ready for this question.
Okay, go for it.
Oh, damn. He came out swinging. I was ready for you,
and
motherfucker.
what he said is, he talked about that he was unhappy with what happened on January 6th, and people told him not to be involved. And he said, I am, because we have to fight. We have to fight in order to keep our country. He didn't say, and this may be splitting a little bit of hairs, but he actually did tell the crowd, go fight. He said, if we're going to protect, if I'm going to do the right thing, we have to fight. Okay? Now, the thing that Simi testified about in particular was the use of the word fight and the methods and language that President Trump used is perfectly consistent with normal patterns of political discourse. And in fact, we provided evidence that showed that fight like hell, fight like your lives depended on, those various iterations are used commonly throughout political discourse.
I'm sorry, finish your thought and then I'll jump in.
So the objective use of the language doesn't shift. I mean, we don't have a President Trump rule where if he says fight like hell, it's violent. And if other politicians, and we included, senators and President Biden uses the term fight like hell, it's not an incitement to violence. We still look at the objective standards. I mean, we made an analogy to federal campaign finance law, Justice Roberts, who said an intent and an effect test is not appropriate. You look at the objective words that someone uses. And the objective words, he said, go down, I know you are going to march down there peacefully and patriotically. He used 2 tweets saying, stay peaceful. And he made a video that said, be peaceful and go home. Now,
I want to let you keep going.
now the petitioners are going to say, look, those tweets don't matter because he didn't say it right. He didn't tell people to go home. He just said, be peaceful. But the objective language is saying, be peaceful. And we produced one witness on the stand who said the instructions I got from President Trump were to stay peaceful because he heard the speech. Yes, sir.
So this just keeps reminding me of something I've struggled with as I've tried to evaluate this particular piece of it. And that is that are we not dealing with clear error review of the trial court's factual findings about those circumstances? And I realize
that thing I was going to bring up,
a lot of those
clear error.
findings were predicated
I
on a
mentioned this
report
earlier.
that never should have come into evidence. But setting that to the side for one moment, aren't we to a large extent stuck with the trial court's findings and findings that were made by clear and convincing standard, even though you chose not to brief the preponderance of the evidence issue that you outlined in the application. So I'm sort of throwing multiple issues in here, but I don't know that we are in a position to say that there was clear error with respect to her findings of his intent and what happened that day and what led up to it, including the reliance on Professor Simi's testimony.
Well, I don't think it's clear error to apply the facts to the proper legal standard. And the court used the improper legal standard in determining what is in sight. Look, the facts are relatively uncontroverted with respect to what actually happened because the petitioners rely entirely upon tweets, videos, and speeches. I mean, that's their case.
But there are inferences that are made, particularly by Professor Simi, about what significance should be attached to things that happened before January 6th, right? So,
and that's a legal standard. And we are saying that the events, the tweets and speeches in the years leading prior is inappropriate under the Brandenburg imminence standard. That is a legal standard, and they should not be considered. So, and we didn't even dispute the underlying facts. We do, of course, dispute the inferences. And I would note that Professor Simi himself said that he did not address intent at all.
Although the trial court did, right? I mean, she found specific.
And it's clear error for her doing that.
Okay.
I mean, that is clear error in those conclusions. But this court can nonetheless review them because it's the application of facts to the improper legal standard. And the facts are the tweets. Look, the facts are all public tweets, public speech, public videos. And we don't contest any of that, what President Trump said in the evidence that was presented at trial. So, so I think this court doesn't need to look at the clear error, because look, it was not just engagement, insurrection. And let me just talk a moment about insurrection. Justice Gabriel, I think a couple of folks brought up the different definitions. Do we have a consistent definition? I think you did as well, Justice. Look, the proponents of liability for Trump used,
Not liability. You said liability for Trump?
or that Trump should be disqualified, the
Okay,
proponents.
but we're not, again, this isn't a Section 3 claim where there's any kind of liability.
Yeah, I misspoke, Your Honor. There's 2, 4, 6, 7 different definitions. The petitioners in their complaint advocate, and I'm not going to spend time unless you want me to read each one of these, but the petitioners in their complaint advocated one standard. Professor Magliocca advocated a different standard. The court adopted yet a different standard. Bowden-Paulson have had yet a 4th standard. Professor Graber provided a 5th standard. The cite to Judge John Kane's grand jury charge, which we don't think has much force, but it has yet another standard. And the Simon Greenleaf treatise that was relied upon has yet another standard. Those are all different standards, 2 of which have been propounded by the petitioners themselves. Now, the petitioners say, it doesn't matter. They all include President Trump. They all include him. But I would suggest that the fact that the actual proponents of this proposition have themselves identified 7 separate and distinct standards, some of which require a public use of force, some of which don't, some of which require hindrance, some of which don't, some of which apply to the Constitution, execution of the Constitution, some of which don't and apply to the execution of a law.
Why don't you focus, because your time is limited, on the one the district court adopted? And any public use of force or threat of force by a group of people to hinder or prevent the execution of the Constitution. What's wrong with that definition?
Way too broad. I think the petitioners actually admitted that a group of people threatening a mailman and preventing him or her from executing their constitutional duties, because that's one of the constitutional powers that Congress has, would constitute an insurrection.
What if we narrowed it to say prevent the peaceful transfer of power of the United States government? Would that be an insurrection?
To prevent the peaceful transfer? I don't think so, and I'm not sure, Your Honor. Look, if you look at historically in the context of how insurrection was used, it has to be for a substantial duration, not 3 hours. There has to be some geographical scope. There has to be a goal of nullifying all governmental authority in an area.
I guess I'm not sure where you said it has to be, where the temporal provision, where is all that coming from? Webster's Third New International Dictionary defines it as an act or instance of revolting against civil authority or against an established government. So you've added a whole lot of conditions there. I'm not sure where it came from.
I would urge you, I think probably the best exposition of that was the state attorney general's briefs and the authority that they provided. Okay, but I think also if you look at sort of the historical record. Now you're going to tell me, Mr. Gesser, you're making it up. And I'm going to say, well, so did the judge. And I'll say, we're all sort of making it up at the end of the day.
Well,
Yes, we are. We're all
Yes,
kind
I
of
just
winging
want to
it.
jump in on this point of how I don't know that we have to come up with a test that's going to necessarily address all circumstances. I guess the question, at least as to insurrection, setting apart whether President Trump engaged in insurrection, but as to insurrection, why isn't it enough that a violent mob breached the Capitol when Congress was performing a core constitutional function? In some ways, that seems like a poster child for insurrection. Why is that not true?
Well, I think what you're sort of saying is the famous quote. I don't know a definition of it, but I know it when I see it.
Obscenity.
That we don't have a workable standard, but we think in this instance it doesn't feel good, and it just seems.
Well, it's more than
wrong.
it's more than it doesn't feel good.
Yeah,
For
that's
purposes
not
of
a good
this
argument.
case, what we need to do is figure out whether what happened on January 6th, one of the things we need to do is figure out whether what happened on January 6th constituted an insurrection. We don't need to come up with a definition for all times and all circumstances.
And I think most common sense thinking folk would look at it and say, you have sedition at one end of the spectrum, and you have levying war is the term that you've used, civil war maybe at the other end, but in between we have these things, insurrection, rebellion. I think we'd agree that insurrection is typically something less than rebellion.
And I would agree with that in the case, and some of the authorities support it, but it's more than a riot. It's more than a 3-hour riot on one building.
Was that just a riot on January 6th?
And we think it's properly characterized that way and not as insurrection. And remember, look, the Constitution, Section 3 says engage in insurrection. It doesn't say in an insurrection. What's the significance of that?
I
think
I
that
would
it
not make that
indicates sort of
argument.
a more, a broader process rather than
no.
a singular limited
an
in
awful
scope
argument to make.
event. And if you look at the Civil War, that was a broad four-year
That was actually
activity.
more than an insurrection, wasn't it? I mean, the Civil War.
Yes.
I believe levying war was the, I mean, insurrection is getting at something less than a war.
Likely, yes. Now, there are lots of instances in the ratification debates and the framing debates, and I think the AG's pointed this out in their memo, that insurrection, rebellion, war, treason are oftentimes used interchangeably by the drafters. And in fact, you look at some of the authorities here, the petitioners cite, they'll shift from insurrection in some instances and draw examples from treason or rebellion. So they are used very interchangeably. So we would argue that, sort of on the scale of violence and duration and scope and organization, the events of January 6th were more like a riot and far less than a rebellion. And insurrection is far closer to rebellion than it is riot.
How would you define insurrection?
Part of my whole thesis is that we can't define it, and that's in part why this is a non-justiciable question. But to the extent you push me, which you are, I would say it requires at least multiple considerations that go beyond what we had here. I think the duration has to be longer than 3 hours. I think the geographical scope has to be broader than one building. And you say, well, that was the U.S. Capitol. True. It wasn't the Pentagon. It wasn't, it was a singular node. The goal wasn't to nullify governmental authority and set up an alternative government. The goal, as if one assumes the predicate that President Trump directed the crowd, which we reject, to delay the certification. That's not nullification. And I understand it's violent and I understand it's bad, but we, as I would submit as lawyers in this process, need to distinguish those gradations because they have meaning. And what I would say is the goals were not as broad as something like the Shays Rebellion or Whiskey Rebellion. The organization, there was very little evidence of a robust command and control structure and that level of organization. The use of force did not involve arms, certainly not the level of arms necessary to overcome.
Well, let me just jump in there, Mr.
And it
Kessler.
wasn't capable of being rebellion. Yes, sir.
Well, the arms, I mean, you make a legitimate point about, there not being a lot of evidence of arms being taken to the Capitol on January 6th, but there were a lot of makeshift weapons that did a lot of damage. I think at least the petitioners are saying 170 people were injured. That's a lot of violence, right? You'd agree. And irrespective of whether people brought guns and knives to the event, I don't know that we need to, pause too much about that when we have that level of violence. What am I missing?
What you're missing is a riot is consistent with using flagpoles and broken up bike racks as weaponry. An insurrection or rebellion is organized deadly force that's going to nullify government authority. I think there's a big difference there. And look, I understand that the violence at the Capitol was not acceptable, but I do think that it is our job to apply legal standards and understand the gradations involved and whether or not this truly rises to the level of insurrection.
Well, why don't you talk about engagement? You've only got 3 minutes and 40 seconds. So, and I'll just ask you a question to help move this along, hopefully. My concern, I guess, would be, I understand what the argument you make. Engage doesn't mean incite. Those are different things. A leader of an insurrection usually is not involved in, or frequently is not involved in the hand-to-hand fighting. They direct it, they organize it, and then they stand back and they watch it. That would be engagement, I would think, if you had an actual insurrection. So help me understand what engage means.
Well, I think that does. And what that requires is sort of a two-way conversation. Hey, you sergeant or lieutenant, I'm the general. I'm going to do this, you're going to do that. That's different than public speeches. Now look, I mean, if there were a public speech and someone said, oh, and made an agreement with the other side and say, when I say during my public speech, the eagle has landed, then we take action. I would submit that that's engage, but that's a much different instance than incite here. Incite is to sort of arouse these emotions only through public speech. It's a one-way conversation.
So if a leader did a more direct, I want you, and let's make this hypothetical. A leader said, President, I want you to go to the Capitol and I want you to take it over and I want you to ensure that they do not go forward on the Electoral College and use violence if need be. That would be engagement even if the leader doesn't go with them?
Very likely, yes.
Okay.
Very likely, yes. If there is an understanding, an agreement, and not some broad inferential conditioning that Professor Simi testified, I don't think that meets the legal standard. But there has to be very definite sort of meeting of the minds that that's in fact going to happen for it to be engagement. Now, it could still be incitement because it's a direct call for violence, which did not happen here. But there is a difference between the two. They do describe. And I would point out that Congress has treated it as distinct. You know, you look at the Second Confiscation Act in 18 U.S.C. 2383, it says whoever incites, sets on foot, assists, or engages in any rebellion or insurrection. So they treat it as differently. And by the way, if I may say, at the end they say, incitement, sets on foot, assists, they shall be incapable of holding any office under the United States, which indicates that the presidency cannot be barred by mere statute of Congress. So there's that language, under the United States again. Consistent usage and pattern of that. Let me just sort of end up in my, wrap up in the last minute here. This was constitutional litigation. Had the shoe been on the other foot, had the secretary taken action and President Trump would have been required to file a lawsuit, that would be constitutional litigation as well. And all of the dangers and infirmities that Frazier warned about, that Kuhn recognized, that happened here. This was an inappropriate forum for this. It should have been a declaratory judgment action. They could have fought out the standing issues and we would have done that appropriately. And that's a pattern that has been followed in Colorado in the past. With that said, if you look at the text and the direct textual application of Section 3, it doesn't mention the president. And every structural piece that we've discussed, the natural and comfortable meaning points towards the president's exclusion. That fits in with a broader fact that it's not enforceable by state courts against a federal official. The court should not have engaged in interpreting engage in insurrection. Certainly the January 6th report was deficient. We ask this court affirm the district court below, but also strike the dicta from the decision as beyond that court's jurisdiction. Thank you very much.
Thank you, Mr. Gessler. Mr. Olson, you got about 3 minutes, 46 seconds.
Thank you, Mr. Chief Justice. In short, Trump claims this case is too hard for courts to decide, that the standards of insurrection can't be determined, but that's exactly what courts do, and that's exactly what the district court did below. And to the extent there's a dispute between courts that reach these questions, our country has a well-worn mechanism for addressing those inconsistencies. I want to talk briefly about insurrection, officer, and then end on the Colorado Election Code. Justice Hood, you asked how far context goes. It does a great deal of work. In Claver and Hardware, this court said, or the U.S. Supreme Court, Justice Stevens said very explicitly that evidence of authorization of wrongful conduct in other circumstances was relevant to whether the speech at issue there was within or outside the First Amendment. And because there was no other authorization, no other evidence, they found the speech protected by the First Amendment. Here, the district court made extemporaneous extensive findings that the speech by President Trump on paragraphs 288 to 298 were there's a long pattern of him saying things, seeing violence, praising that violence. He used those exact same words on January 6th.
Is Simi's testimony subject to clear error review? Are those facts that the trial court ended up making based on his testimony subject to anything other than clear error review here?
They're subject to clear error review, but the court didn't just rely on Simi's testimony.
I know.
She set forth a number of facts, of statements by Trump himself where there was violence. And in the speech on the lips, there were 20 times he called to fight, which is a literal call to violence. He said that 20 times. It wasn't in the prepared speech. He did that so that people wouldn't know that he was going to call people to march to the Capitol. He was going to incite them to violence. Hess also looks at the rational inference from the import of language. And there's no better evidence of what happened than evidence that Trump didn't object to below. And that was Brad Parscale, his former campaign manager, in real time on January 6th said, "We are seeing, quote, a sitting president call for civil war." That easily meets the incitement standard under the First Amendment. And I was amazed. There's a tweet at 2:24 p.m. on January 6th. Trump never mentioned it in his briefs below, never mentioned it at trial.
Then what?
He
You
was
can't bring
describing
it up
what
now.
happened on
Why are you?
January 6th
You
today.
should stop.
He ignored the tweet on January.
You don't get to bring
on
it up
January 6th
now.
at 2:24, which sent the mob into a frenzy. There was unrebutted testimony that that
bring it up
poured
now.
gasoline on the fire and caused the Capitol to be breached. If this is not incitement, I don't know what is. Secondly, Justice Hood, to your question about is there a meaningful alternative procedure, you heard there is none. What Trump wants is for everyone to take a pass on this issue and then create the ingredients for a second January 6th coming up on January 2025.
Oh, yeah.
Justice Gabriel, you asked about
Another
presidential
insurrection.
electors being a bulwark against electing Jefferson Davis. That won't work because only those that have taken an oath before the insurrection are disqualified by the 14th Amendment, Section 3. Electors, insurrectionists can be electors. They just can't be oath-taking insurrectionists. And finally, Justice Marquez, on the concern about the 22nd Amendment being enforced by the Secretary of State here, if I may finish, Your Honor, briefly.
Briefly.
Yes, thank you. Here, on this fact pattern, Trump certified to the Secretary of State using the statement of intent that he met, quote, all qualifications to be president. Her putting him on the ballot with that certification is a wrongful act under Colorado Election Code and is why we bring this case under 113. And nowhere in the election code, anywhere in the election code are any presidential qualifications mentioned. The only way we get there is by bringing in the constitutional requirements into the freestanding election code that we talked about earlier. Thank you all very, very much for your consideration of this case. Again, we urge that the court affirm below with the exception of the officer decision. Thank you very much.
All right. I want to thank the counsel who made argument. I also want to thank the attorneys that provided the amicus briefs. I think it goes beyond, I think, the average appreciation for how hard people have worked in the time frame that this has been required. And I want to compliment the quality of the work and the professionalism. So with that, the case will stand submitted and we will be in recess.
All right, that's it. It'll be interesting to see where this goes. Like I said, I think the court's going to uphold what happened down below and just leave it as it is because they both did not make good arguments about how to overturn, the standard for overturning the lower court rulings. Do I think that's where it's going to end up? Yeah, I think that's just where we're going to be. That said, though, it was really interesting. We're going to stop this, and I'm going to get back to taking over. Now, I did want to get to a couple of questions that were asked earlier. And one of the first ones I want to address is Buster. You mentioned all the interruptions. It's not an issue of unfairness. There's questions that need to be addressed. And, the court has the right to ask those questions, and those questions eat into your time, yes. But I think it was necessary. They're asking questions they feel is necessary to flesh out the issue. So it's not really a big problem in that regard. I don't worry about that particularly compared to other things. Getting to some of the super chats real quick. Stephen Cooper for $2. Thank you, Stephen. Says shout out for Dr. Evil making it to court. Yes. Yes. And then Kelly R says $5. That guy's working really hard keeping his lisp under wraps. Yep. Yes, he was. And then Kelly for $10 more. Thank you, Kelly. Thank you for the support. I appreciate it. Saying, when you have time, can you talk about why this got addressed in the Colorado Supreme Court? I mean, the court did not have to hear this correct. They could have declined the appeal. I think they had to take this appeal because there's no other place for this to go. I think this is an issue that under Colorado law, they have to hear. So I think this was something that had to go to them. And I understand what you're saying there. And actually, guys, give me 1 second. I will be right back. Sorry about that. We're back. So, and part of the issue here, though, guys, is I don't know all the cases they were arguing. Scott Gessler, the person arguing on behalf of Donald Trump, is a former Secretary of State for Colorado. So you may have heard him talking about arguing some of these cases before, Frazier, things like that. It's tough when we don't know what they're arguing from because it's Colorado law. I have no idea about it. Richard says, is there a legal definition for insurrection? In the United States Code, I believe there is. Yes. There is a legal definition of insurrection. And we looked at, according to the United States Code, which is what the U.S. laws are based on, the codification of them, whoever incites, sets foot, or assists or engages in any rebellion or insurrection against the authority of the United States or the laws thereof. So there is an actual crime of insurrection. And notice no one's been charged with that. So, and Trump hasn't been charged with it. So I think that throws another issue in there that it's a administrative finding he engaged in criminal conduct. Because the idea that insurrection is a crime, it's a grievous crime against our country. The idea that you're going to you're going to make this determination, that's not what we want to see. That's not how we want to address it. Mr. Squiggle says he sounds like an actor reading a script. Well, when they're doing your beginnings, you've got your introduction. You generally are allowed to run through your introduction, your preamble, without interruption. So, I guess saying how can a president insurrect while he's still in office? That makes no sense. That's actually not impossible. I mean, if you're the president and you launch a coup, like you're gonna J-damn Congress and take over and become, Julius Caesar, you could do that. You could launch an insurrection against your own people. I mean, think about it. I mean, you go back to Charles I, the King of England, in the English Civil War. He was charged with waging war against his own people. How can he, how can you do a war against your own country? I mean, it is not hard to do. It's just very, very rare. I hope that kind of answers your question there, because that's kind of the way I can come up with an answer. Lunatic bro, yes, and this is part of the issue. It's a very, there's ambiguity. What do you do? Because it doesn't say the president. And it talks about a different oath. So what do you do? And I think there's ambiguity. When you run into ambiguity, a court has to figure out, is that ambiguity meant to be there? What do we do? How do we handle this? Adam K says, how can a state court prosecute insurrection? They can't. And this wasn't a prosecution. This was an administrative hearing. So the administrative hearing, the judge made an administrative finding. That wasn't a criminal hearing. That the standard was not beyond a reasonable doubt. It was preponderance of the evidence. Actually, I think it was preponderance of the evidence, but the judge determined, preponderance is 51%. And she claims they did clear and convincing, which is like 60-some%. So that's why it wasn't a there. I hope that answers that. Terry, hello, Terry. I don't think I've seen you before, but thank you for stopping around. Saying there's no time constraint when the justice posed questions. That's correct. There are some times where you're just getting machine gunned with questions. Sometimes in the Supreme Court, you've got, and I've done one appellate argument. And yeah, when you're up there, I was okay. I had a chance to get my speech out. But I've also seen people before, and sometimes you see the Supreme Court arguments, the justice just question after question after question. You don't get to answer anything but questions. And remember, the questions may not determine where they're leaning because they might be clarifying things so they can make their decision later. So just be careful about reading the questions too much. Did I upgrade my airbrush yet? I didn't upgrade it, but I'm working it better. That's the key. Using it better is the big thing. But thank you for noticing. And Kevin, I will say there is I do have a channel where I'm going to be doing a lot of the model stuff. It's called Sean's Unsexy Modeling. And if you want to subscribe there, you can. I would appreciate it. I'll grab the link for that. I thought it was funny because it's not sexy modeling. Just a little bit. Actually, wait, hold on. Switch account, grab that. Oh, come on, you're killing me. So here is actually, if you want to help me out and give me some subs there, I'd appreciate it. I'll start putting stuff up there soon. That's where I'm probably going to start doing my model stuff just because I don't want to ruin the algorithm too much more. So let's see here. The judge sounds like a Redditor with his reasoning. But remember, sometimes to be fair, Gessler at times had Redditor level explanations. So, and there's times where they're asking a question to get to another question. Sometimes that question is not the ultimate goal. There might be a secondary or tertiary issue they're trying to suss out. So try to be careful about, but I get what you're saying, and I understand where that's coming from. Drew M is a new member. Thank you, Drew. I appreciate the support. Thank you so much. And then there are some other... Richard O, you asked this earlier. For £5. Sterling, the King Sterling. Out of all of LawTube, which lawyers would you be most wary and least wary of facing in court? To be honest, it all depends on the settings. Where we are, what are we doing? If I was like in an appellate argument, would I be worried about Steve? Yeah. If I was in an appellate setting, do I think I might be better off against, like legal vices maybe, or, legal mindset because they haven't done appellate stuff? Maybe. But the thing is, and I think this is where this is pretty much everybody on LawTube is a very competent attorney. To sit here and think, oh, I could take them on. I have never seen, other than Steve putting up some of his appeal arguments on camera, I've never seen any of them out on the field. Like, I don't know how they act under the lights. I don't know their quality of work. And I think it is a foolish endeavor to assume you're going to roll someone up. You are far better off assuming you are going up against a capable and knowledgeable adversary, because that means you prepare and you do what you can. And then if it turns out you're wrong, great. So no, I would deem them all worthy adversaries until proven otherwise. I mean, that is a very big thing. It's very determinant on what side you're on, because sometimes your facts are screwed. Sometimes you have nothing. For example, if let's say I went up against Emily Baker and she's the prosecutor, I'm the defense attorney, but my guy's on camera, forgot to pull his ski mask down, and he's on camera with the pistol going like this, the 7-Eleven at Kirk's head. There's only so much I can do with that. So there is a very determinative issue about the facts. And I think it's very hard to sit there and say, oh, well, I'm going to make it so you guys have an equal case. There generally is. That's usually not how things work out. One side's generally right. One side's generally wrong. Are there times where there's some gray area, a little bleed over? Yes. But I think it's fair to say a lot of times one side's got the upper hand over the other. So, you might sit there and think, oh, that was a pussy answer, but that is the answer I'm going to give you, because that's the answer I really view as correct. Turn saying, did I hear about Josh's en banc review? Yes. Kiwi Farms got denied an en banc review by the 10th Circuit. So that means the current 3-judge panel's ruling stays in effect. That just means now Russell Greer. He's kind of they can go on to pass summary judgment. That's all it means. It doesn't mean anything else at this point. Now, Noel can appeal this, but we'll see where that goes. I mean, appealing the Supreme Court's not going to get him where he wants to go, but he has every right to. So we shall see. And Richard, you asked us earlier. I wasn't trying to ignore you. It's just we were already in the middle of stuff. So I hope you're still here, Richard, because I tried to answer the best I could. And Rich, yes. Whoa, Brad Parscale tweeted, case closed. Yes. Cringe says, I wear a Baldo. It's official now. Yes. You got me. If you listen closely, you can hear it vibrating too. If Judge Hood isn't there, do they say where the hood at? Yes. Where the hood at? Term saying that was hella grim. I don't think you. I think the court's going to have to punt, and I think they realizing they're going to have to punt, but they have to ask these questions. They have to figure out. I mean, certainly, they are. To get to a Supreme Court level, you are a very intellectual person, very cerebral. They had a lot of questions, and I think those questions, some probably were answered, some were not, and then, yeah. Cedar says, how long till we know the verdict? We don't, because they're going to have to sit down and talk about it. It's just like the Supreme Court of the United States. They'll meet and confer. They'll make their decision on who's got the right argument, one way or another. Then it'll start getting drafted. I mean, it'll be fairly quick, because January 5th is the certification date for the ballots for the primary. So this has to happen pretty damn quick. And there isn't a lot of time. And also remember, it's December. So we are we're 2 weeks, we're about 2.5 weeks away from Christmas. I mean, think about it. Nobody's going to want to get crap done the week before Christmas. So, tick, 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 tick. Very good question, though. But the answer really is I don't know. I don't know. I have no idea. Keopathic says, my shirt matches the courtroom carpet. I'm an inside man. Yes. A lot of courtrooms have red carpet. I mean, this I would have blended in if I laid down on the Supreme Court of Ohio's carpet. I mean, aside from being like a big speed bump, yes, the red would blend in. Richard O says, Alyssa's already got my finest moment thus far on stream. Perfect. Oh, when people are calling, yeah, no, those calls I had to take care of. Those were actually important calls. So, excited utterance saying, "Hey, how are you doing?" By the way, saying, "Have you been following the Becky Ethics Commission complaint drama?" Yes, and I'm going to be talking about that tomorrow on my weekly live stream. Which, if you're new here, every Thursday night at 9:30 p.m. Eastern time, I do a live stream and we talk about things throughout the week. What types of cases going on? I mean, for example, what's going on in the Murdoch case with Becky Hill, the clerk, her son being charged and arrested, her cell phone being seized. There's going to be some things in the Gabby Petito case. There are some revelations that Brian Laundrie's parents apparently knew and that he had confessed that he had killed her or that she was gone, and whatever gone means. Ricky Vaughn, also known as Douglas Mackey, the guy who did the meme, the election voting meme, and was sent to prison, has been granted appeal bond, meaning his case is going to be heard on appeal and he's allowed to be out while that's done. And that's a pretty big indicator the court's a little skeptical of things. There's a lawsuit involving George Floyd Square over in Minneapolis. It's a very interesting one. And then there's for example, a guy walking up to a lady's door and says, "Well, I'm going to rape and kill you." It's a very weird one, but I think it's something worthwhile to look into and talk about. So there is a lot of things to talk about tomorrow night. Obviously, things going on with President Trump in this case. Also, what's going on in his cases over in D.C. I know Robert Gavea kind of does those every time, but daily. But this will be more of a kind of like a roundup of them. So yeah, that is a Thursday night crime stream. It is at 9:30 Eastern time. So yes, 9:30 Eastern time, not Central, not Mountain, anything like that. Cringe says, "Don't let my emergency pizza expire." Yes. But yes, excited. I'm going to be working on that. There's a lot there. We're learning that Becky Hill was doing tours of the courthouse, and you do a donation. But all those donations went in her pocket, and she apparently forged a check and got the name erased and made it out to her, which that's a big no. That's forgery, among other things, theft in office, a lot of issues that really kind of bring light into the idea if she's willing to run around and, I mean, she's engaging in financial crimes. And guess who? She said Alex Murdaugh's a piece of shit. Don't listen to him. Well, Miss Becky, I guess the shoe don't fit on your foot down, done it? Hoo-wee. And can you trust this woman to be correct? Nah, screw with the jury. I don't know. Keith Alex is dropping JDAMs on Congress should be legal. Yeah. When am I starting the foamer channel? I am not a foamer. You guys are going to make me cry. And Buster's right. Judges can ask questions without revealing what they're thinking. Yes. Just me says I remain unsub. I gotta remain unsexy. Yeah, you don't have to worry about that. I can't change that. Even if I lost all the weight necessary, I still have a face for radio. Let's see. Okay, out of all LawTube, who do you think you could take in the ring? And I'll include Kino Casino in that, as well as Alyssa. I mean, yeah, I could probably punch Alyssa in the face. She's small. There's a lot of people I could probably kick the ass of. And not because I'm fast, it's just because I could probably take a hit or two and, get into where I need to go. I don't think I could beat PPP. He's a big guy and he's a lot taller. I think that would be tough. That would be tough. And also, Worski's gone in the ring, man. He can throw. My very lawyery answer was acceptable. I'm glad it was. Thank you. Excited Utterance is a new member. Thank you very much. I appreciate that. I appreciate your support. Thank you very much. So where actually, I'll keep that going. That'd be 6:30 Pacific time, yes. DC Killing Spree says if Murdoch doesn't get a new trial, I'll eat my hat. I will too. I'd be very concerned if he doesn't get one. Amateur Iconoclast says the Soto Parish Sheriff's election voided. Let me see here. Can you send me some information about that, Iconoclast? Because I just Googled and it didn't give me anything right away. Jacob Peets is saying, what was the fuss over the insurrection versus an insurrection argument? I mean, I understand it's poorly worded, but you seem to be opposed before the utterances of the argument. Oh, I don't necessarily have an issue with calling it an insurrection versus an insurrection. I think that the issue is that was an administrative determination, and insurrection is an actual crime. Now, yes, there are times where you can you can be like, I can murder somebody, get found like OJ. He was found not guilty of murder, but in a civil trial, it was determined he was liable for the wrongful death of Nicole and Ron Goldman. Okay. I don't think you can apply that standard here of saying an administrative hearing can assign that level of culpability to somebody and determination-wise. I think that's my issue more than anything. And if I didn't answer it, please ask again and re-clarify, because I'm a little confused. Like, I'm not necessarily confused, but I'm not sure if I answered your question right. So I could beat Joe, just drop a handful of nickels in the ring. Jeez. Surret saying Worski through the fight. Well, who made the money? Because I don't know if anybody bet on it. So, yes, if he did it. If he did it. So, all right, guys, that, like I said, I don't know how this is going to shake out. I have a feeling the court's going to say, yeah, this is this is a political issue. And, the Supreme Court did bring up the whole thing, like, well, what about the Supreme Court of the United States? Because that's the next stop from here. Should they do something, it goes straight to SCOTUS. And Scott Gessler made a correct statement saying, you can't rely on them. You guys got to make the right decision now. And I think they're going to make the right decision. I think they're going to leave it as it stands. The thing I see being a problem is for Trump going forward, other states, if there's still the ability to contest him for November, and I don't know, because they mentioned California's post-election. Well, I don't know how that works with the primary, or does it mean only at the end? Or I don't know the time windows and time frames. And maybe even if somebody's trying to get on a primary ballot, you have to do it now. They can use the fact that this Colorado judge determined he committed insurrection and use that in their, filing saying, look, a judge has already done this somewhere else. But I don't know how other states would do that. And I'm actually not 100% sure how that would work here in Ohio. I have done election cases. I have represented people and I have done election challenges, but I'm not sure in this situation how that would work under Ohio law. And that's something I'm actually might want to look into. Like, how would I try to disqualify Trump here in Ohio? It actually might be a good video. I'll have to work on that. Phone Punk says, why doesn't Trump's lawyers use Democrat-endorsed insurrections as counter arguments? Well, and they did to an extent. They did the whole fight thing. As far as an actual Democrat-endorsed insurrection, if you're arguing about what happened with Chaz in Seattle or Chaz Chop, that's not going to work because I don't think there's a good enough endorsement or anything you can use that would truly sustain an argument in a court case. I think most of these justices would laugh at it, and rightly so. Nico says, lost it after Joe said small children run away, terrified after seeing him. Yeah. Yes, that was a very funny show last night. Let's see here. What else do we have? Anything else starred? Oh, Ghost of Speedy. You said this earlier and I didn't get to it, so I apologize for $4.99. Thank you. Saying Nick now defends movies like Cuties and jokes about taking advantage of kids. Seems to be a requirement for those who kiss the ring of Dick Masterson. Yeah, I mean that's part of. Like I said, I don't know what's changed, but something's changed, and that's why I don't know what it is or what's happened there. But it's clear something's different, and hope it unchanges, to say the least. But for now, it looks like it's not. But yes, Cuties is a god awful movie. Creepy as hell. There's nothing cute about it. Ha ha ha. No pun intended. Yes, cringe peddler. No, it is you who have changed. Stalker. Yes. Alpha Fox says a lot of these arguments have been brief, so the court may not address during oral arguments. And that's true. There were multiple amicus briefs sent in on both sides. Now, those people don't get to speak, but the court's going to read through them. I mean, they've read through them. They're reading through them. They're going to read through them now. There's a lot of stuff that's out there. They might address their questions. And they might be asking a question raised in an amicus, hoping that this could be answered by one of the parties. So there's a lot out there. There's a lot of information that was presented. And we'll see what happens there. That's who we are. It says Baldo mind control. Yes. It's a hell of a mind control device then. Keopathic says a friend of the court is no friend of mine. Well, I mean, I've written an amicus before on a much, much more mundane issue. But yes, I guess, why can't we be friends? Why can't we be friends? I've never heard amicus pronounced like that. Oh, what do you mean? What's amicus? Oh, and you guys are like, I was like, yeah, what's amicus? Oh, amicus? There's amicus, amicus. It's amicus, amicus. I say amicus curiae, amicus curiae. So, I'm simple folk though. I'm unsophisticated. I only went to state schools. I didn't go to a fancy law school, so that's why. Amicus. Or amicus. Yes. Amicus cream or amica cream. Yes. Yes, it means to be a friend of the court and you're submitting further options to the court information. Dana McCoy says, Sean, exclamation point. Yes, hello, Dana. Erroneous Nomius says, Rabbit, 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 rabbit. It's not the first of the month. So, Alpha Fox says, I went to the top law school in my state. Get wrecked. Is it really the top law school if it's the only law school? I'm just saying. The best law school in American Samoa. No, I think you said you went to West Virginia. I think Marshall's got a law school, but I think that's it. I don't know where else does. Cornfield University, we learning Huskin law. Yes. That said, though, you can joke about that, but if you have a law school in a state where there's a specific industry, you will get a focused program on that. You can get, mineral law, mining law, land use. There's all kinds of things. So if you're on the coast, you can get maritime law, like focuses. You can get like certificates, which are really kind of just junk, but you've taken more classes. So, yeah. Nico says there's foamer law. Yes, there's railroad law. That would have. Yes, that's if you have a professor who's a normie, that would have been great. It's like, this is foamer law. So you can advertise yourself to help foamers when they get arrested. But generally speaking, the issues surrounding foamers would be just trespassing on the railroad properties. Only West Virginia, not Marshall. I thought Marshall had a law school. Really? No way. No way. Like that guy on TikTok. No way. Fuck's sake. Really, it's the that's interesting. I would have thought they had one. Keopathic says, I only have a simple realtor's license. Riparian rights is more law than I needed to know. They actually make you guys learn that for a realtor's license? That's kind of impressive because that's not, that is, I mean, it's not super hard, but, Stabby's talking about, it's surrounding how things, a proposed in 2002 for Marshall, nothing happening. Okay. Air rights, drones, and a telephoto lens. Yeah, that's becoming an issue. I mean, the law surrounding drone usage, cities are regulating it, the FAA is regulating it. That's going to be a whole thing going forward. A whole thing going forward. A whole new world. Call it a whole new world. If you happen to not like Ukrainians. That's a joke. It is a joke. You can't take it too hard because it's not a wiener. Cedar Rose says a cool segment would be covering historical and obscure trials in early America. There might be some out there, but I would point out that I think Rob and Ian Runkle, Runkle the Bailey, and who were doing that? They were doing like Trials of the Century, I think is what they called it. So I could be involved in that, but there's only so much I can really cover because I mean they've already done that. I mean I feel like that would be a bit of a rehashing of things. So I don't know how much I would be able to do that would be beneficial or fruitful to the discussion. So it's just something to think about. But I keep that in mind. There might be some other ones we could talk about. Jay Bet says, I wonder how drone laws will be enforced. It's going to be interesting how it goes. Stabby says, remember, folks, Sean has a public P.O. box. Yes, it's down below. P.O. Box 716 in Willoughby, Ohio, 44096. Gifts and model trains. Not model trains. If you're going to, look, you're going to send me models, like if you're really going to do that. Model airplanes, model tanks, model boats. Those are all fun. Trains are kind of like just mainly paint jobs, and I mean, I'm not really big on the paint jobbing, so yeah, stick with those, and don't give me like the snap-on kits, like the little kid kits, like My First Models, because some of those you can snap together. Those aren't fun. Yes, killdozers. Well, I'm trying to find a good bulldozer model to start with that, because even though I have the kill, so hard. You guys don't understand. This is hard to do when you're mirror imaging things. This guy right here from Stabby, this is a 3D printed killdozer. I am going to work on a kit bashed killdozer with some little more detail on it. Kit bashed says model Gundams. I've not done a whole lot of Gunpla, but if you send me one, I'll work on it. I'll put one together. It'll be interesting. So, yeah, I'm just saying, if you send me a Gundam, I'll work on it. I think Gundams are pretty cool. Just never did one. Vodka Blood says, I think my state only has one public law school. It depends on your state. If you go into like the American Bar Association, say credit them, you can find out pretty quick. Winter Soldier says it did not like the dozer. What didn't like the dozer comment? Oh, Autobot grabbed you? I think maybe because, well, hold on. It still showed up here. But that is how Twitch works. Twitch giveth and taketh away. So. Chris is doing 1-to-1 scale killdozer. Yeah. With a surplus APC kit bash. Yeah. Get a hold of a Bearcat and just scrap it and put it on. Or at this rate, order one of the destroyed BMPs from Ukraine and have it sent here. Get the plasma torch out and just weld on BMP armor. That'd be interesting. Put the 30 mil turret on the top. Just Meat Candy says the RC killdozer win. Well, I gotta build it. I want to make it look good. Uncle Marv, I want to make it. It's gonna be. I'm gonna do a correct one for Uncle Marv. Iconoclast says, don't forget the cope cage. Well, they're all using. That's a cage that they put on top of the tanks in Ukraine right now on both sides, because the drones are hitting them and blowing them up. Well, if they put a cage around it, the drone hits it and blows up the cage. Yes, they're all using cages right now. I am so hoping you guys are not going to make another joke about cages that you could right now. I'm really hoping that gets avoided, because I could see that happening, and I don't want to have to deal with it. That's when you're like, then why are you talking about it? It's like, maybe I'm a glutton for punishment. All right, guys. I think that is really it for now. Unless you guys have other questions, anything else you want to say? Goading us to do it, yes. Chris says they thought about putting the Baldo on top of the tank. That'd be interesting. Just like bounce right off. Okay, guys. Bryce is saying, Bryce Cooley, say, hi Bryce, by the way, so you got to give Newsom credit. He has the balls to go in the line set on Fox News, answering I don't think, yes, but to sit there and say Sean Hannity is a tough person to take questions from, or anybody in Fox News at this point, is a tough person. Fox News is a joke and hollow shell of what it used to be. But I do understand, yes, he went on there. But I would argue it's far more of a tame environment than going on to MSNBC or something like that. So, but yes, he did go in there. He gets credit for that. Mofo says, how's your P80? I need to get a hold of some punches and knock out the pins and get that bar that transfers a little bent, because apparently that's my biggest issue. But we'll find out. If you guys are wondering, in honor of Halloween, I took a Polymer 80 Glock frame and carved it up and made a spooky ghost gun for Halloween. Kia Patrick saying civilians legally can't own jammers. Well, you can own. I think it's more of an issue about turning one on versus owning one, because you can go on to Amazon and you can buy Spectrum jammers, which do exist and apparently work fairly well. And for example, here's a great example of that. Now we're getting into the Minecraft part of the show. You could change what frequencies it jams. Well, some of these are very kind of wide spectrum jammers. But yeah, there you go. That's example of one jammer you can buy. What else can you buy? There's also one that's being sold for. There's also a very cheap version of one of these that goes for less than $60. That has been widely used in South Africa and in Mexico by the cartels and really bad guys. So let's see if I can find it, because it is truly impressive what you can buy on Amazon if you're looking, and what comes out of China. Oh, no, these are just the Faraday bags. Well, you know what? I am, yeah. There are ways you can block stuff, and it's, the issue about buying them is not really the problem. So just look at the FCC spectrum chart to get ideas. Yes. Drew says they use a lot of different frequencies now. Yes, but you can use those, with that information, you can then, once you know the frequencies, then you can, if you tear apart the jammer and play with it, well, you can then use it yourself. So there's, like I said, you just got to be, you got to be smart about it. Keypad says, I figured Amazon having those were honeypots. Maybe, maybe not. Can buy rolls of Faraday cloth on Amazon. Yes, but I can't run around my neighborhood and block signals with Faraday cloth. Squiggle says, do they work? Apparently, yes, they work very well. If you go on Twitter, there was a picture of dudes wearing them. Like some cartel hitmen, each one having one of those strapped to them. And like, as they're getting ready to do work, they turn it on. So. Meat Candy says, what frequency could you jam FBI HRT comms? If you're jamming HRT's comms, you have the ability to jam. You're jamming like MPU 5s, which can like zombify like Telus radios and Harris radios, which I don't know how if you're doing that, you have other nation support, so you're not in trouble. You're having a good day already. But the short answer is, if you need to jam military level encryption. That's the only way you defeat that, because they're going to run. They're running, DevGru level, Delta Force level stuff, the HRT. So, Cringe Player saying Christmas gift ideas with Sean. Yes, always good ideas. Hunch the Dirty Roofer for $5. Thanks, Hunch. Says Spectrum jammers, so they are anti-tism. Yes, they are broad spectrum. The whole spectrum. So, thank you, Hunch. I appreciate the support. Yeah, I'm trying to find, because I was talking about one before, and I can't find it. Oh, by the way, guys, it sounds like Taylor Swift is now Times Person of the Year. Congratulations, Tay-Tay. You earned it. Good for her. And if you guys do, actually, hold on here. I think I might have a down spot for it. Let me see, because we do have a Minecraft section of the forum on Discord. What if I have it there? Hold on, guys. We're trying to see if it shows up. Yeah, dang it, I can't find it. So, yeah, I can't find it. That is Oh, yep, here we go. Yeah, I found it. Oh, looks like Amazon may have taken it down. Oh no. The jammer's gone. Because it was a jammer for $50. Yeah. Looks like Amazon caught on. Kia saying, Sean's getting ready to wrap up. Make one more off comment about jammers, and here we are. Minecrafting. Yes. So, all right, guys. That is... You guys are making fun of Tay-Tay, especially her older stuff. She took the English language and, this guttural shit that spews out of our mouths. And like a blacksmith, she beat on it like a piece of iron and turned it into beautiful art. Not everybody could do that. And that's, she'll be seen as the next Bach when she passes. So that is it, guys. I will see you around. I will see you tomorrow. Unless something big happens. I'm hoping, knock on wood, nothing happens. But until then, yes, we will be back tomorrow night at 9:30, and I will see you guys then. A lot of stuff to talk about. Nika says, more blacksmith talking, please. You can talk about that over on Locals. So that is it until next time. And remember, just because you did it doesn't mean you're guilty. I mean, nobody's really guilty here, but we'll see how this one shakes out. I think it's going to be a little up in the air, guys, but we'll see. Take care.